This webinar is in regards to title. Everything that we are talking about, everything that we do is relating to title. So let's go over what I think title is about. Title is the union of all elements constituting the legal right to control and dispose of property. Title is the legal link between a person who owns property and the property itself. Title is the legal evidence of a person's ownership rights or interests in the property. Title is the manner in which the right to real property is acquired. The conditions necessary to acquire a valid claim to land. Title is the right itself, the legal consequences of such conditions. This is what everyone is fighting for, whether they understand it or not. It's not about ownership. It's about rights acquired to control and dispose of property. That is one of the biggest things I must stress to you. When someone is talking about I own. What do you own? We're going to be talking about law. Law is different than equity. All right. The majority of the people go into a court of equity. A court of equity is a court which can apply equitable remedies to disputes. These courts operate within the legal system, but rather than focusing upon the application of law, they look at cases and determine outcome based on fairness. In other words, you and the banks are going to sit in a circle and you're going to sing Kumbaya. Now, specifically, a court of law must follow the black letter rules, while a court of equity has the ability to do which it deems is fair and equal. I'm sorry, people, but fair and equal is not in my book. I want to be in the court of law, not a court of equity. So, it is time to go on the offense. Instead of going to a court of equity and getting beat up by the courts, determining upon themselves as to what is fair and equitable in this instance as determined by other cases of foreclosure, we're going into a court of law, as this matter we are bringing them is all about law. It's not about equity. I am the plaintiff. I am saying to the court, Your Honor, the defendants are attempting to exercise a right on the plaintiff's property without lawful authority to do so. Now, although mortgage servicers are able to foreclose under Texas Property Code, that ability derives from a principal-agency relationship with the owner of the indebtedness and that of a perfected right to real property. Okay. Is the volume correct for everyone? If not, type in the chat and I will try to raise it even louder. Okay. So again, we're talking about equity versus law. Now, one of the things that we need to look at, all right, this is my opinion as to what I see is going on. All right. When we're talking about declaratory judgment, all right, let's take a look at what that means. A declaratory judgment is a legal determination of a court as to the legal position of the litigants in cases where there is doubt as to their position in law. It is a form of legally binding preventive adjudications by which a party involved in an actual or possible legal matter can ask the court to conclusively rule and affirm the rights, duties, or obligations of one or more of the parties in a civil dispute. Now, although generally it is generally statutory rather than an equitable remedy, all right, this has nothing to do with foreclosure. It is a separate standalone action. Now, the declaratory judgment by itself, order any action by any party or any damages, what it is doing is you're asking the courts for a status quo determination as to the parties that have acquired rights in accordance with law. Because what we're saying is that they have not acquired any rights in accordance with law. Okay? Now, when we're talking about how this is done, all right, there's a few things that we need to do first. All right? We need to have an understanding of parties that are claiming to take part. We need to identify parties entitled to enforce using statutory requirements of law on mortgage loan instruments. In cases where the promissory notes fulfill the technical requirements of negotiability, then we go to Article 3 of the Uniform Commercial Code or your state's equivalents of. If you were in Texas, we'd go to the Texas Business Commerce Code. If we were in Florida, I'd be going to Florida's 673 statutes. So again, whatever your state's equivalent to the Uniform Commercial Code, that's where we would go. We need to understand who is Pete, all right? Because we would go to your equivalence of 3-104, all right, which talks about who is the person entitled to enforce a mortgage note and to whom the obligation to pay the note is owed. So first thing we must do is we have to identify the person that is entitled to enforce the note. Okay? Now, the owner may not be the person entitled to enforce. All right? So the reason is that we need to identify Pete. All right? One, we need to see that for Pete, that is the maker's obligation of the note to pay the amount of the note to Pete, meaning it is a homeowner's obligation to pay on the note to the person entitled to enforce. All right? Now, if someone is coming forth as Pete, all right, then we need to look at the ways that the Uniform Commercial Code or your state's equivalent of states that they may come forth. All right, one of the things is that it says that it requires the person to be in possession of the note and that either the note is payable to that person or the note is payable to bearer. All right, bearer, B-E-A-R-E-R. Now, this would require an examination of the note and any subsequent endorsements. All right. Now, the second way that a person may be peat, all right, would be a non-holder in possession of the note who has the rights of a holder. Now, a non-holder may have the rights of a holder if delivery of the note of that person constitutes a transfer as defined in Uniform Commercial Code Article 3 or your state's equivalent of. Because a transfer of a note vests in the transferee any right of the transfer or to enforce the instrument, all right, and that's under UCC 3-203B as in boy. All right. Now, if the payee delivers a note to an assignee, all right, that means that I'm going to deliver the note to a third party without endorsing it, all right, the assignee will not be a holder of the note, all right, because a note is still payable to the payee. The person that is claiming possession, that is in possession of the note, they need to demonstrate the purpose of the delivery of the note in order to qualify as peat. So you need, the person that's delivering needs to show, here, I am delivering this so that party B may enforce it. But again, the mailman can be a holder. However, he has not acquired rights, so he would not be peat. Now, the third method does not require possession of the note, but it is limited because it only applies in cases which the person cannot reasonably obtain possession of the instrument because the instrument was destroyed or lost. All right, and in that case, all right, they would then go to UCC 3-309 subsection A, subsection III or 3. And that states in which such cases a person qualifies as a peat, person entitled to enforce, if he demonstrates not only that one of the circumstances is present, but that the person was formerly in possession of the note and was entitled to enforce it when loss of possession occurred, and that the loss of possession was not a result of transfer or unlawful seizure. Now, what they're saying is that that person that's claiming it's lost must have acquired rights in accordance with law before they lost it. So you cannot just do a lost note affidavit based on a hearsay claim, even though that is what they do, and this is why we must dispute it. So when someone is claiming to be peat, all right, they must show that they are peat. Okay, so there's a lot of things present when we're going into peat. All right, now, when we look at it a little more deeper, all right, let's go here. Here we go. I just put this together so you can actually see. All right. So here's what we're talking about. All right. This is Article 3. Now, again, I'm just going over the Federal Uniform Commercial Code. For your specific state, we would just break it apart to your state's equivalent of, depending on what state you're in. California Commercial Code, Arizona Title 47. So whatever state you're in, if you're in New York, we're using UCC 1961. So for me today, majority of the ones I will be going over are just federal statutes. I've got some specific ones, again, for depending on what state you're in. So we talk about UCC 3412. All right, person entitled to enforce, here in abbreviated PEAT, is defined in UCC 3-301. Person entitled to enforce an instrument means, one, the title of the the holder of the instrument. 2, a holder in possession of the instrument who has rights of a holder. Or 3, a person not in possession of the instrument who is entitled to enforce the instrument pursuant to section 3-309 or 3-418 subsection D. And then we go through the holder. What is a holder? Holder means, okay, someone who possesses a negotiable instrument made payable to his or her order or properly negotiated to the latter by a proper chain of endorsements. Okay. This is very important, a proper chain of endorsements. We do not go from party A to party D as in dog. It's A to B, B to C, C to D, D to E. All right, so again, we need to have an understanding of that. We go to holder, okay, we're going to go to Uniform Commercial Code 3-412. Obligation of the issuer of note or a cashier's check. Okay, it says, the issuer of a note is obligated to pay the instrument, okay, according to its terms at the time it was issued. The obligation is owed to a person entitled to enforce the instrument. Okay, so we know that. That's what it's saying. A person in possession of the negotiable instrument that is payable either to bearer, B-E-A-R-E-R, or to an identified person that is in the possession. An identified person. All right, now, and then, and by 3-203, that's UCC 3203. It defines what is to be done. Negotiation means transfer of possession, whether voluntary or involuntary, of an instrument by a person other than the issuer to a person who thereby becomes its holder. All right, so again, we need to understand who is this party coming forth to be Pete. Okay? When we get into negotiation, we talk about a proper negotiation of the note creates holder status in the transferee and makes the transferee a Pete, person entitled to enforce. Now, these two terms complement each other, where holder is taken through a valid negotiation, and a valid negotiation leads to a holder status. Now, there's two ways. There's a blank endorsement or special endorsement by the original payee of the note. Now, with the blank endorsement, and we're going to go through this later, I'm going to show examples of endorsement, special endorsement, blank endorsement, and a few other endorsements as well. So we're going to show you what it looks like, because what is happening is that they're using fancy word crafting, and what Party A will tell you a blank endorsement is, they're giving you their interpretation as to what a blank endorsement is. So we'll get into statutory requirements law for blank endorsements and special endorsements in a little while. All right, so through either blank endorsement or a special endorsement. With the blank endorsement, one that does not name a new payee, the payee simply signs its name on the back of the instrument. All right? If an instrument has thus been endorsed by a payee, anyone can acquire the note and is a Pete. How many people have taken a check? And let's say you receive a check from your significant other. And you take this check. And they say, can you please run down to the bank and go grab some cash? Here's the check, run and go do it. So you run down to the bank, and you're not thinking, you think check's already filled out, and you hand the check to the teller, and the teller says, oh, okay, excuse me, Mr. Esquivel, you didn't finish filling out the check. Would you mind filling it? And you're like, okay, what's wrong? Oh, you didn't name a payee, paid to the order of without recourse, it says, or sorry, just as paid to the order of, and then there's an empty space on the check. So you fill your name in, or you write cash, and you hand it back. Then they hand the check back to you and they say, excuse me, but you didn't sign the back of the check. You're like, oh, silly me, you know. You sign your name at the back, you hand the check back to the teller, and a second later the teller hands it back to you. Excuse me, I need to see some identification, please. And suddenly you realize you've left your purse or your wallet at the house. It's happened to me a few times over the years. And, you know, I remember going to the teller and saying, listen, you know, Tanya, I've been coming here for 10 years. You know me. I'm sorry. I need to see some identification. I just can't take your word that you are who you are. That's the law. I need to see some identification. The parties need to be identified. That is not what is happening. All right? Now, because you can't take the check in cash, you then get the check and you go back. And when you get back to the house, you hand the check back to your significant other. You say, oh, I forgot my wallet. You're going to have to go cash a check tomorrow. Here. They then take that check, all right, the next day. Now, you've signed the check. All they do is go to the teller, present identification, and sign their name below your name. It is now a bearer instrument. You have endorsed it in blank. Just signed your name. All right? And that is pursuant to 3205C. As to what is a blank endorsement that consists of a signature alone. Because what we're talking about are true sales. And when we're talking about sales, we need to talk about the documents as they are required to be filled out in accordance with law. Okay, so again, Pete is not what you think it is. The person entitled to divorce, they must have acquired rights, all right, in accordance with law. Now, what I'd like to do is to go through some of these documents because we're going to take a look at, we talk about in order to be Pete, you must have taken documents in accordance with law. And you would have done that through an assignment of mortgage. You would have done that through an assignment of deed of trust or through an assignment of security deed. Now, the purpose of an assignment of mortgage or an assignment of deed of trust is to memorialize transactions pertaining to the negotiable instrument, being the tangible promissory note, and the acquiring of rights in accordance with law. This assignment of deed of trust or this assignment of mortgage, all right, does not cause the sale. The sale is caused through statutory requirements of law. This assignment just memorializes it. So when we look at these documents, one of the things that we need to do is we need to, let's shrink this a little bit, all right, look at a few things. When we're looking at it, we're looking at what county was it filed in? What date was it recorded on? All right. What time was it filed? Okay. What is the instrument number? And the reason that this is important because many times when these are filed, they will file many documents all at once. The problem is that you must be timeliness. There must be a timeliness of filing in accordance with law. Secondly, when they file these, they're not always done correctly. All right. You can see based on the boxes that are in red as to everything that needs to be looked at when you are looking at an assignment. This particular one is an assignment of mortgage. Because in order to be Pete, all right, the assignment is memorialized in transaction. So if this is memorialized in the sale of a note that pertains to a deed of trust, everything needs to match. Okay? So when we're looking at the assignment, that assignment memorializes a transaction that pertains to this note. So on this note, all right, I'm looking at, is there endorsement to a named payee? Because it is going from payee A, all right, it would say assignment of mortgage for value received, the undersigned corporation. So the undersigned corporation would be, in this case, it's MERS. So MERS is assigning it to Citibank. Well, so if they're transferring an assignment of deed of trust, and that assignment of deed of trust is just the beneficial interest of personal property, not real property, all right, then it should match. There should be a transaction on the tangible promissory note reflecting this. If there is no transaction on the tangible promissory note reflecting any transactions that have taken place, then all they have assigned, all right, is what they have acquired in accordance with law. If you have not been, what's the word? If you have not acquired any rights at all, you cannot assign any rights. If you have not been proffered anything, then you cannot assign anything away. So if I'm going to state that I'm transferring the beneficial interest in a deed of trust together with the note, just because I do an assignment, that doesn't cause a transaction. It is this endorsement, transfer, and delivery, and in a timely manner, which causes a transaction. So these documents, when we look at them, that assignment that was to be done to memorialize this transaction, right? The assignment, once the assignment is done, all right, then they do a substitution of trustee, all right? And the substitution of trustee, again, this would take place in a non-judicial state such as California, Nevada, Arizona. In judicial states with mortgages, you do not do a substitution of trustee because the mortgage is in the name of the lender to begin with. So in California, in your deed of trust states, they do the assignment of deed of trust. They then do a substitution of trustee based on the new beneficiary of the assignment. Then once they do the substitution of trustee, they then do a notice of default from this new trustee that is named on here. So everything is all connected. All of the documents that are filed in public record need to match the chain of endorsements on the tangible promissory note. They do not. So this is why it is so important when we're going through these documents to look at it. Look at the dates, look at the amounts. They may seem trivial, but it's these little things that that we catch them in. When we do the investigation, all right, who are the parties that are being named? Because it is these parties that are attempting to be Pete, person entitled to enforce. All right, so when we're looking at that, again, documents are very, very important. So when we're going for declaratory judgment, again, have you acquired rights in accordance with law?
Hey everyone! Are you looking to sue your bank for mortgage fraud or foreclosure fraud? If so, you should call Fraud Stoppers right now, because we'll show you a proven way to help you save time and money and increase your odds of success, getting the legal remedy that you deserve. Remember, when the banks break the law, we break the banks. So call us today. Until then, see ya.
Majority of the time they have not. All right, let's take a look. Okay, at some negotiable instruments. When someone talks about bearer paper, I'd like you to have an understanding as to what is bearer paper. All right, this says, all right, if you take a look at this, it says, will pay the County of Rockbridge, will pay to bearer at the office of the County Treasurer 10 cents. Will pay to bearer, B-E-A-R-E-R. Right? That's a lot different, all right, because again, it says will pay to bearer. Here, the all-new bearer instrument, payable to bearer on demand. This is for Bitcoins. Okay. Here's another example. All right. This is a gold certificate. All right, this says, the bottom line below the $100 in gold, it says, payable to bearer on demand as authorized by law. There is no empty space. It says payable to bearer. This is bearer paper. Here's another one. This is a Federal Reserve note. Again, it says, will pay to bearer on demand. So when someone is coming forth to me and they're saying, Joe, they're claiming this is bearer paper. Okay? I have to ask them, do they have an understanding as to what pay to the bearer means? Does it say, will pay to bearer? Does it state, pay to the order of bearer? No. It's a form of fancy word crafting. So we need to look real hard and have a good understanding of what they're talking about when they come forth with these documents. I apologize for that drop. Okay. Here is order paper. Paid to the order of. I am stating a specific set of instructions. All right? Now, when it says paid to the order of, there's intent. I intend to name a party. This is bearer paper. Pay to bearer upon demand. Big difference from this one, paid to the order of. And yet we have attorneys after attorneys after attorneys that state, Joe, you don't know what you're looking at, it's bearer paper. Well, fine, let's get out statutory requirements of law. Let's look up bearer paper. Let's look up order paper. Because misconstruing the law, all right, is what is done a large number of times. And when you leave the courts to have their own interpretation as to how to interpret what you're trying to put forth, that is why we get all this bad case law out there. Okay, so let's go over. This is UCC 3-109. Payable to bearer or to order. A promise or order is payable to bearer if it, 1, states that is payable to bearer, or to the order of bearer, and that or otherwise indicates that the person in possession of the promise or order is entitled to payment. 2, it does not state a payee. Or 3, states that it is payable to or to the order of cash, or otherwise indicates that it is not payable to an identified person. So that's pretty easy. So it's stating that a promissory order is payable to bearer, again, right there. All right, if it states that it is payable to bearer, or if it does not state a payee, okay. 3, states that it is payable to or to the order of cash, or that otherwise indicates that it is not payable to an identified person. Okay, 3B. A promissory order that is not payable to bearer is payable to order if it is payable, 1, to the order of an identified person, or 2, to an identified person or order. A promissory order that is payable to order is payable to the identified person. All right, so if it states paid to the order of, that is showing intent. Now, C, an instrument payable to bearer may become payable to an identified person if it is specially endorsed pursuant to Section 3-205A. An instrument that is payable to an identified person may become payable to bearer if it is endorsed in blank pursuant to Section 3205B. And 3205B states that through signature alone. So in other words, if you just write your signature as on the back of a check, right, then someone can come and take that and cash it. But again, through signature alone. What is a blank endorsement? What is an endorsement? So we're going to go to, again, this is UCC 3-204 or your state's equivalent thereof. Endorsement means a signature other than that of a signer as maker, drawer, or acceptor. That alone or accompanied by other words is made on an instrument for the purpose of 1, negotiating the instrument, 2, restricting payment of the instrument, or 3, incurring endorser's liability of the instrument. But regardless of the intent of the signer, a signature and its accompanying words is an endorsement, unless the accompanying words and the terms of the instrument and the place of the signature or other circumstances unambiguously indicate that the signature was made for a purpose other than endorsement. So, let's see. I don't have. All right. So when we look here, all right, we're talking about endorsement, a signature. So if there is no signature, there is no endorsement. Now when we go to special endorsement, blank endorsement, again, we need to understand what is a blank endorsement, what is a special endorsement, what is an incomplete instrument. We'll go into that in a minute too. So UCC 3205 talks about special endorsement, blank endorsement, and anonymous endorsement. A, if an endorsement is made by the holder of an instrument, whether payable to an identified person or payable to bearer, and the endorsement identifies a person to whom it makes the instrument payable, it is a special endorsement. So if it's saying paid to the order of, right, it's naming a specific person. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement, you can put in the word signature of that person. The principle stated in section 3-110, that's UCC 3, apply to special endorsements. And we'll get over that in a little bit, because that goes to identified parties. Section B, if an endorsement is made by the holder of the instrument and is not a special endorsement, it is a blank endorsement. Okay. When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by the transfer of possession alone until specially endorsed. Okay. We're going to cover B in a second. Let's jump down to C, because B is what they say. Well, if it's not a special endorsement, it must be a blank endorsement. Yes. When endorsed in blank, take your check. How do you endorse a check in blank? By signature alone. Now we jump down to C. The holder may convert a blank endorsement that consists only of a signature into a special endorsement by writing the signature of the endorser, words identifying the person to whom the instrument is to be made. All right? You still need to sign your name in order to have this endorsement. So paid to the order of shows intent. We know what your intent is. But until the payee is named, you cannot be identified, and this is an incomplete instrument. When we go to UCC 3-206, we get into restrictive endorsement. Paid to the order of, without recourse, is one sort of restriction. So a restrictive endorsement is stated under Section A. An endorsement limiting payment to a particular person or otherwise prohibiting further transfer or negotiation of the instrument is not effective to prevent further transfer or negotiation of the instrument. B, an endorsement stating a condition to the right of the endorsee to receive payment does not affect the right of the endorsee to enforce the instrument. A person paying the instrument or taking it for value or collection may disregard the condition, and the rights and liabilities of that person are not affected by whether the condition has been fulfilled. And C states, if an instrument bears an endorsement, 1, described in section 4201B, or 2, in blank, or to a particular bank using the words for deposit, for collection, or other words indicating a purpose of having the instrument collected by a bank for the endorser or for a particular account, the rules apply, following rules applies. What we're talking about is, are they placing restrictions on what is to be done? Are they placing any type of restriction on this endorsement? So when we see the words without recourse, that means without any limit, without any warranties and representations. They're taking that note, and the minute you take that note, the person from whom gave you the note is no longer liable for it. It's without recourse. If you want to have fun, go to a bank, and when someone writes you a check, say you have a check for $500 and you go cash it. All right? When you write your name on it and you hand it to the teller, if that bounces, you are blamed for that bounce, and they will charge you a fee for collecting that money. They will then strip that money from your account a week later. Now, if you write the words without recourse and hand that to the teller, they freak out because you are no longer liable for that check. You've given it to them without recourse. Here, take it. It's yours. If it bounces, it's on the bank. It's not on you. They've accepted the check. So if you want to have fun, that's something you can do. All right, now we're going to continue. There is only one statute in the entire Uniform Commercial Code that pertains to the acquiring of rights. And that is under UCC 3-203. Now, again, whatever your state's equivalent is a little different. We're going to go to New York, and we're using their 1961 codified version. That is under 3202, not 3203. And instead of A, B, C, and D, or 1, 2, 3, and 4, it's just 1, 2, and 3. So again, there's a little variation, but the other 49 states have a codified version that is about 99% similar to what we have up on the screen. A defines what is to be done. B, C, and D place restrictions on how it is to be done. Or if you're in, say, you're in the state of Florida, instead of A, B, C, and D, it's 1, 2, 3, and 4. One would define what is to be done, and B, C, and D would place restrictions on how it is to be done. Now, in this case, we're just going to use Uniform Commercial Code as applied in federal law. So this states under 3203, transfer of instrument, rights acquired by transfer. A, an instrument is transferred when it is delivered by a person other than its issuer, for the purpose of giving to the person receiving delivery the right to enforce the instrument. Okay, so that defined what is done. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the rights to enforce. Okay, so that defined it. Now, let's go to B. B is going to place a restriction on it. B states, transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transferor to enforce the instrument, including any rights as a holder in due course. But the transferee cannot acquire the rights of a holder in due course by a transfer directly or indirectly from a holder in due course if the transferee engaged in fraud or illegality affecting the instrument. So, if there was any fraud involved or any illegality involved, then the transfer of rights, the transfer of the instrument, does not take place. C, unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor, but negotiation of the instrument does not occur until the endorsement is made. So they're saying, if there is a lack of endorsement on the note, no negotiation occurs and does not occur until the endorsement is made. What is an endorsement? A signature alone. I've seen half a dozen notes, on a monthly basis that are preferred to courts, and there is no endorsement from party A to party B on the note. So it's saying right here, unless otherwise agreed, if an instrument is transferred for value, all right, and the transferee does not become a holder because of lack of endorsement, negotiation of the instrument does not occur until the endorsement is made. Now, when we jump down to Section C, it states, if a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. All right. The transferee obtains no rights under this article and is only the rights of a partial assignee. So let's break this down a little bit. The entire instrument. The entire instrument consists of the tangible promissory note, the intangible payment obligation. That intangible payment obligation is I promise to pay. All right? and the security instrument attached to that intangible obligation, which is evidenced by the tangible promissory note. So if they have transferred only one part out of the three parts necessary, then negotiation does not take place. So for them to transfer the entire instrument, we must have must be named to the note, must be named in public record, and it must be timely. And you must be the sole party with sole claim to the intangible obligation, which is to be evidenced by the tangible promissory note. So again, let's use Fannie Mae, for example, or Freddie Mac or Ginnie Mae. If they only acquire a partial interest of your mortgage loan instrument, have they acquired the entire instrument? No. You're not named to public record. They're not named to your note. Nothing is timely. And yet they claim Fannie Mae owns your loan. Well, I'm sorry, but I don't understand. I need you to explain to me, what is a loan? You see everything in writing, and everyone talks about, I'm the owner of the loan. They bought your loan. What did they buy? Who bought it? Mickey Mouse, Donald Duck, Goofy? It doesn't matter. You must inquire the entire mortgage loan instrument, and it must be timely and in accordance with law to acquire rights, period. I didn't make this up. These are just comments. Now, let's look at endorsements. Again, we've gone through, there's a blank endorsement. All right? Special endorsement, paid to the order of. I'm given a specific set of instructions. Restrictive, for deposit only. I'm restricting how it is to be done. That's different than paid to the order of. Now in here I'm specifically saying I need a person name, paid to the order of, and then you fill it in. Here, for deposit only, again, I'm restricting what is to be done without recourse. All right. This is UCC 7501. Again, forms of negotiation and requirements of due negotiation, where we talk about following rules apply to negotiable, tangible documents of title. Okay. Let's go through this real quick. A, the following rules apply to a negotiable, tangible document of title. 1, if the document's original terms run to the order of a named person, the document is negotiated by the named person's endorsement and delivery. After the named person's endorsement in blank or to bearer, any person may negotiate the document by delivery alone. True. Again, is negotiated by the named person's endorsement and delivery. Now, if that named person were to sign it, all right, their signature alone would create a blank endorsement or to bearer, then any person may negotiate that document by delivering a loan. 2, if the document's original terms run to bearer, it is negotiated by delivery alone. I've yet to see any note state payable to bearer. 3, if the document original terms run to the order of a named person and is delivered to the named person, then the effect is the same as if the document had been negotiated. Well, if it said to the order of a named person and it was delivered to the named person, yes, then it would have been negotiated. 4, negotiation of the document after it has been endorsed to a named person requires endorsement by the named person as well as delivery. 5, a document is duly negotiated if it is negotiated in the manner stated in this subsection to a holder that purchases in good faith, without notice of any defense against or claim to it on the part of any person, and for value, unless it is established that negotiation is not in the regular course of business, or financing or involves receiving the document in settlement or a payment of monetary obligation. So this statute pertains to negotiable, tangible documents of title. All right, what I'd like to do is take a few minutes because we're going over statutes and we're talking about timeliness. We're going to go, while we're in statutes, and this one I'm going to go through, I think I have Florida up, I just happen to have it handy. You keep hearing me talk about timeliness for a person to acquire rights. Timeliness, timeliness, timeliness. All right, did they acquire the entire document in accordance with law? Well, let's take a look at this. Because the acquiring of rights and the perfection of secured interest is what we're talking about. Each one of the 50 states out there, including Puerto Rico, has a statute that pertains to secured transactions. And this one we're going to perfection and priority. Now, under UCC, it would be UCC 9-312 and subsections G through H. All right. In Florida, we're under Florida State's annotated statute 679.3121. And we're going to be talking about, it says perfection of security interest in chattel paper, deposit accounts, documents, goods covered by documents, instruments, investment property, letter of credit rights, money, perfection by permissive filing, and temporary perfection without filing or transfer of possession. Now, Article 9 pertains to real property, or personal property, I apologize, not real property. So this is personal property. All right? Now, we're going to get down to sections 5 through 8, or I believe it's in sections E through H if you were in, say, California. All right, so it talks about here, starting at 5. A security interest in certificate securities, negotiable documents, or instruments is perfected without filing or taking possession or control for a period of 20 days from the time that it attaches to the extent that it arises for new value given under an authenticated security agreement. Okay, so it's saying that this security interest, all right, in a negotiable document or instrument is perfected for a period of 20 days. 6, a perfected security interest in a negotiable document or goods in possession of a bailee other than one that is issued a negotiable document for the goods remains perfected for 20 days without filing if the secured party makes available to the debtor the goods or document representing the goods for the purpose of A, ultimate sale or exchange, B, loading, unloading, shipping, storing, transferring, manufacturing, processing, or otherwise dealing with them in a manner primary to their sale or exchange. We jump down to 7. 7 states, again, a perfected security interest in a certificate, security, or instrument remains perfected for 20 days without filing if the secured party delivers the security, certificate, or instrument to the debtor for the purpose of, again, A, ultimate sale or exchange, B, presentation, collection, enforcement, renewal or registration or transfer. Now we jump down to Section 8. 5, 6, and 7 have all said that there is a perfection of 20 days. 8 states, after the 20-day period specified in subsection 5, 6, or 7 expires, perfection depends upon compliance with this chapter. Now, after 20 days, if you have not perfected, and how does one perfect? One perfects an instrument by filing into public record. If I was a mechanical contractor and I didn't get paid, what would I do? I would have a period in which to go file a lien against the property in which I did work. All right, so I would get a perfected mechanics lien against the house. Now, so if someone is selling a negotiable instrument, being a tangible promissory note from party A to party B, you always hear the mortgage follows the note, Joe. I'm telling you, the mortgage follows the note. The mortgage follows a properly perfected note. Because the minute you're done at closing, what do? They take your documents, they take your deed of trust, they take your mortgage, they take your security deed, and they send it to public record. Why? Because it gets indexed, filed, and recorded, giving constructive notice to the world, all right, that perfection has been achieved. There is now a lien on the property.
You can't touch this. You can't touch this. You can't touch this. You can't touch this. My music hits me so hard, makes me say, oh my Lord, thank you for blessing me. What am I to rhyme and to hype me? It feels good when you know you're down. A super dope homeboy from the Oak Town, and I'm known as such, and this is a beat.
Okay. So now when I sell that tangible promissory note done through negotiation, transfer, and delivery of the instrument, all right, I'm going to endorse it, transfer it, deliver it from party A to party B. At the same time and in tandem, I'm going to do an assignment of mortgage or an assignment of deed of trust in which I release my interest in this instrument, being a deed of trust or a mortgage or a security deed, and I'm assigning that personal interest in that instrument from party A to party B. I file it in public record. I gave constructive notice to the world. I've now established a perfected lien that party B now has. Party B then decides he is going to sell this. And he does it through negotiation, transfer, and delivery and endorsement. Boom. Takes it, hands it to party C. He has endorsed it. Same time and in tandem, he does an assignment of deed of trust or an assignment of mortgage. Releasing party B's interest, assigning to party C. This is then filed with county records, where it is recorded, indexed, and filed. Again, there is also a timeliness issue. 20 days. On day 21, by operation of law, that temporarily, and it says temporary, right? This word here, temporary. That's what it says. Oops. Goofing this up. All right? It says temporary. A temporary perfection. So, after 20 days by operation of law, if you have not permanently perfected your temporary perfection of the instrument, Humpty Dumpty falls off and he cannot be put back together again. He cannot be put back together again. So, let's break this down a little bit. If Fannie Mae purchases an interest of a mortgage loan instrument for John Doe, and yet 8 years later, John Doe goes into a presumed deficiency on payments of an intangible obligation which had been purchased by Fannie Mae, but yet Fannie Mae is not named in public record. Fannie Mae is not named to the note But yet Fannie Mae claims secured creditor status at foreclosure. They're listed in the complaint. How did they get there? Did it happen by osmosis? No. Nobody is calling them out. This is why our investigation is so critical to laying the foundation of any action going forward. Again, declaratory judgment is one where we're looking at. And again, depending on what state you're in is depending on how it would be done. So again, we're talking about temporary perfection. And this is for all 50 states, temporary perfection of security interests. And this is personal property. It's not real property. All right, let's go now. We talked earlier about UCC 3110 and as it pertains, all right, to bearer paper, all right, or to endorsements. This is Florida. Again, so this is FSA, Florida State Annotated Statutes 673-1101. If this was federal, it'd just be UCC. All right. That's what it would look like if it was federal. All right. So for Florida, again, every state has their own version. It basically says the same thing. So it's under 3110, or again, we just go to Florida. Identification of a person to whom instrument is payable. So there are statutes that state, one, the person to whom an instrument is initially payable is determined by the intent of the person. Determined by the intent. Paid to the order of. Does that show intent? You darn tootin' it shows intent. So let's continue this. The person to whom an instrument is initially payable is determined by the intent of the person, whether or not authorized, signing as or in the name or behalf of the issuer of the instrument. The instrument is payable to the person intended by the signer, even if that person is not identified in the instrument by a name or other identification that is not of the intended person. Okay, so it's saying that the parties must be identified. They must be identified. And yet the banks, they blow right by it. So this is why, again, when we're doing our investigation, many times we use the statute, if I have a copy of the note, where the person is not identified. So we're showing, hey, wait a minute, law says the person must be identified. You hear me talking about UCC 3-115, or your state's equivalent of. This is Florida state's equivalence of 3-115. Incomplete instrument. What is an incomplete instrument? One, the term incomplete instrument means a signed writing, whether or not issued by the signer, and the contents of which show at the time of signing that it is incomplete, but that the signer intended it to be completed by the words, by the addition of words or numbers. So let's do this. Am I not showing intent right here? I'm showing that I intend to name a party that has not been identified yet. Now, if this is passed through, let's say, 5 different parties, all right, It should have gone from Party A to Party B, Party B to Party C, Party C to Party D, Party D to Party E. Instead, it goes from lender to Party F. We don't know who Party F is. They're not identified. Where are all these subsequent transactions? There is no agent-principal relationship that can be shown. Without no agent-principal relationship, they're just baseless hearsay claims that no one is attacking except us. So understanding statutes, people, is very, very, very important. And when you understand what an incomplete instrument is, again, the light bulbs come on. So for me, this is one of those, that needs to be taken care of, incomplete instrument. Again, all 50 states have it. All right. The question is, are you going to use it? All right. So give me a quick second. So what I'd like to do next, I'd like to go into, let's see. All right, this is for Florida. And again, depending on what state you're in, we're going over a lot of the statutes. So you have an understanding, everything that we're talking about is about in accordance with law. Some states have statutes similar to this one. This one is Florida's. So from Florida, this says false pretenses and frauds generally. Wow, false pretenses. So under Florida, section 817535, it says, unlawful filing of false documents or records against real or personal property. A, file means to present an instrument for recording in an official record or to cause an instrument to be presented for recording in an official record. Okay. B, filer means the person who presents an instrument for recording in an official record or causes an instrument to be presented for recording in an official record. C, instrument means any judgment, mortgage, assignment, pledge, lien, financing statement, encumbrance, deed, lease, bill of sale, agreement, mortgage, notice of claim of lien, notice of levy, promissory note, mortgage note, release, partial release, or satisfaction of any of the foregoing, or any document that relates to or attempts to restrict the ownership, transfer, or encumbrance of, or claim against real or personal property, or any interest in real or personal property. So when you do an assignment of mortgage, you're doing an assignment, all right, of a personal interest and a security instrument attached, or that was to be attached to an obligation which is evidenced by a tangible promissory note. So Florida has a statute that says, hey, it is against the law to file false documents or records. I'm not making any of this up, everyone. We're talking about using the statutes that are there. The problem is very few people have an understanding as to what is there. We don't need to reinvent the wheel. We need to maintain the use of the wheel correctly. We need to make sure that it spins around. Don't drag the damn wheel sideways. Spin it. Okay, so let's continue. So again, this just again, we've got a number of states out there that do have statutes out there pertaining to filing of false instruments. There's federal statutes. We have 18 U.S.C. Chapter 47, 1021. That is a federal statute that talks about filing of false documents. So I'm not making any of this up. I investigate wrongdoings and I bring them to light. When we talk about color of title, what is color of title versus title? A person has color of title to a piece of property when for one reason or the other, the document evidencing title, meaning a deed of trust or a mortgage, all right, is invalid. So that assignment of mortgage or that assignment of deed of trust gives an appearance of a legally enforceable right of possession or ownership, but that's all it is. It purports to transfer ownership of property. All right. Again, it purports, on the face of it, you're looking at it and you're saying, wow, they're doing an assignment of mortgage, Joe. Or wow, they're doing an assignment of deed of trust. Now, the document that's purporting to pass title to land, all right, it's defective due to a lack of rights acquired. So you can claim that you're doing a purported assignment of mortgage or a purported assignment of deed of trust, but if you've acquired no rights, then you've transferred no rights. And that's the whole purpose of getting an order from the courts determining the status quo of the parties. That assignment does not cause the sale. The sale is caused through negotiation, transfer, and delivery. Again, go back to 3203, 7501, 3110, 3115. These are all statutes that we use in our investigation and the analysis that lay the foundation for going forward with a declaratory judgment. So again, we need to have a clear understanding what it is that we're talking about. I've had a few people, including lawyers, tell me, Joe, Uniform Commercial Code, that doesn't work in my state. I'm sorry, but you know what? You're just not understanding what's being said. We can go far back before the Uniform Commercial Code, all right, and go back to Negotiable Instruments Act of 1881. Right? What they don't realize, we've been doing trillions of dollars in commerce, all right, for decades. This is 1881, all right, and they talk about in 1881, the main object of the Negotiable Instruments Act is to legalize a system by which instruments contemplated by it could pass from hand to hand by negotiation like any other goods. The purpose of the act was to present an orderly and authoritative statement of leading rules of law relating to negotiable instruments. To achieve the objective of the act, the legislator thought it proper to make provision in the act for conferring certain privileges to the mercantile instruments contemplated under it and provide special procedure. All right, so they had promissory notes. Again, this is going back to 1881. The Uniform Commercial Code didn't come about to 1961. And all 50 states have codified a version of it. So when someone says, Joe, well, it doesn't apply, I'm sorry, but you don't have a correct understanding as to how to use the law. You have a state version of codified statutes regarding negotiable instruments and security interest of security instruments. So one needs to have an understanding of these statutes before we make any statements. Don't give any admissions at all. So we need to understand that. First and foremost. All right, so let's continue. So I just want to bring that up because I have people tell me, well, Joe, it doesn't apply in my case. I'm sorry, but there are laws that have been in place before the RMBS market came about. The RMBS market did not come about to the early 70s, and it was started by the Salomon Brothers, which is a investment bank. So now when you look at prior to 1970, we had billions and trillions of dollars in commercial transactions taking place all the time. And they used Uniform Commercial Code at that time. And no one has ever had a problem with it. The problem is that upon the creation of the secondary market, being the RMBS market, residential mortgage-backed security market, everybody decided to make their own rules. Well, I don't want to follow these guidelines. We're only going to follow ones that apply to us. And we're going to pick which ones we want to follow. And if nobody questions it, all right, their silence is acquiescence. They have accepted that what the banks say is true and correct. And if you object, you must object completely and accurately. When you only make half a statement, the courts can only give half a ruling based on what you have presented. There is a reason all of these rules were brought in place. You know, we've got the Securities Act of 1933, the Exchange Act of 1934. Whenever there is a dispute among the big boys, among the investors, among the titans that control the market, they're going back to the Securities Act of 33. They go back to the Securities Exchange Act of 1934. Right? Because after we had the Depression, right, which was from 1929 to 1932, the Security Exchange Commission came in and said, hey, wait a minute, you know what? You guys are taking everybody's money. We have certain rules that are in place.
Hey you, my name is Little Tony, and I'm in the garbage business, as in taking out the garbage, if you catch my drift. Hey, it's not like I'm being subtle here. Now listen closely, because I got a message for you. Turn on those ear holes. If you're currently experiencing a little difficulty with your mortgage, aka you're facing foreclosure, you got three basic options. Option one, you could sit there like a potato and let them steal your happy little home. You gonna do that? I don't think so. You don't look like a potato to me. Option two, you could sue the bank for mortgage fraud. Now, for option two, you're gonna wanna call Fraud Stoppers because they can show you a proven way to save money, save the moolah, and increase your chances for success. And who doesn't like to succeed? Now, I do have another option that I don't usually bring up. You could hire me and the boys for a little shakedown action, or a mock funeral if you know what I'm talking about here, or a real funeral depending on how far you're willing to go on this issue. But I gotta warn you, option three, it's gonna cost you 10 large, and it's a risky. I mean, I don't want to mention any names, but the last guy who picked option three, he got pinched, and now he's doing a dime at Folsom. Not the best place to do a dime. AKA, he's singing the blues like Johnny Cash. And I don't know about you, but I don't like singing. So, do yourself and the family a favor and call the boys at Fraud Stoppers today. Because when the banks break the law, Fraud Stoppers, they break the banks. Now, get out of here. We're all done. I'll see you around.
I'm stuck in Folsom Prison, and time keeps dragging on. But that train keeps a rolling on down to San Antone. When I was just a baby, my mama told me, son, always be a good boy, don't ever play with guns. But I shot a man in Reno just to watch him die. When I hear that whistle blowing, I hang my head and cry.
And this is how we came about with the 424B5 rule, which states that a prospectus must be given to the investors, all right, prior to any investment taking place. All right. So now when you look at the Securities Exchange Act 1934, that regulated the secondary trading of securities between persons, all right? Because today trillions of dollars are made and lost each year in trading on the secondary market. But there are rules in place. You just have to know what rules apply. What do I need to do to hold their feet to the fire? One of the cool things out is it's called the IRS Publication 938. And again, this is when you're disputing if there is an entity that is claiming rights, in addition to filing with the Securities Exchange Commission, all right, if they're going to have a company that is putting out a PPM or an offering for investors, all right, they need to file with the SEC, Securities Exchange Commission, and they need to file with the IRS. And when they file with the IRS, it's under IRS Publication 938. And this is a quarterly publication. And this publication, it states all of the RMICs that are applying to be a RMIC, all of the entities that are filing. A RMIC is a real estate mortgage investment conduit. It's a pass-through entity in which this company is set up to be tax deferred. Now, some of the requirements are that they must file with the SEC, they must file with the IRS. You need to list all the information. So whether it's Bank of America, okay, whether it's Citigroup, Freddie Mac, all right, they put the classes, the tranches, all right, they're going to put the startup date. What date are they to start? 12/30/09, 11/24/09. Now, on that startup date, all of the assets need to be with that trust. They cannot start that trust up and running until all the assets are in it. Again, we've got Freddie Mac, we have Ginnie Mae, we have Ginnie Mae Platinum. So regardless whether you're Fannie Mae, Freddie Mac, Seawalt, we all have rules we must adhere to. So they list all of their tranches. These are tranches. Now, depending on the investor's risk of loss that they're willing to take would depend on what tranches they would be put in. Many of these trusts are set up with different groups, Group 1, Group 2, Group 3, because they set up these RMICs, real estate investment conduits, so that many different types of investors can invest in one product. So if you're a conservative investor, you can say, well, I'm happy to just make a lower payment every month, but guaranteed. Right? So you want something safe. So we're going to put you with our senior tranches. And then you have someone who's a little more willing to take a chance, and they're saying, well, you know what, I could wait 10 years for my money. You know what, I'd rather have a little more money, and I'm willing to take a little bit of risk. Well, we're going to put you in Group 2, tranches, 5 through 6. All right? And you're going to be second collecting. And then we've got, say Group 3 or Group 4. And this is someone that's young or someone that has time they're invested in. Say, you know what, I could wait 15 years for my return. You know what, I'm willing to get a higher rate of return, take a little bit of a chance on the money. This isn't my primary source of income. I'm willing to throw the dice. All right, and they're going to be in Group 3. Again, depending on whatever trust you're in, they're all set up different, but again, they have many qualities that are very similar. So the tranches are paid in a waterfall effect from the top down, from the senior classes down to the junior, down to the junk. However, they're paid off from the bottom up. So many times you will see, if anyone who is familiar with looking at a Bloomberg screenshot, that half a dozen tranches have been paid off. And you have the gentleman that's on the phone with you telling you, you know what, Mr. Smith? Oh my gosh, I've noticed 5 tranches in that trust that you're in are paid off. Your loan is paid. Well, in effect, that person talking to you doesn't have a clue in the world, because many of those tranches are set up for a shelf life that is based on a select number of years or based on a monetary amount being paid out. And whatever comes first, either the monetary amount being paid off or the number of years expiring by operation of law, that tranche expires. That trust is still there. That asset that was sold to the trust is still there. The person explaining it to you just doesn't have a clue what they're talking about. Many times you hear people talking about, well, Joe, I'm with the CDO. Collateralized debt obligation. Joe, they took out an insurance policy on my loan. Joe, they're selling all of these CDOs in this trust. It does not matter. The CDOs don't pertain to the homeowner. Don't worry about it. It's like a side bet in poker. It has nothing to do with you. What you need to be looking at is, what is the startup date? What is the issue date that these trusts are to be starting up on? If they are to start up on the set date that they were given, all right, from the IRS, again, all these have dates that they're starting up on. By that date, that is when the assets need to be in the trust. So now when you question, well, Joe, they did an assignment, I'm in an 06 trust. Well, that 06 trust had a startup date in January of 06, but yet they did a assignment of mortgage in 2013. Was that past the startup date determined by IRS in the IRS publication 938? Again, it doesn't matter if it's Fannie Mae. Fannie Mae has startup dates, issue dates. You just need to look. So all we're doing is we're just taking the documents that have been created by others. Again, you hear me talk about when we're speaking, we must speak clearly and correctly, because what we're thinking about and what we're talking about many times are two different things. So we're going to go through real quickly definitions, because I'd like everyone to understand when you talk to me, I'm talking about, are we talking about your electronic note? Are we talking about your electronic mortgage? Are we talking about the tangible promissory note? Are we talking about the intangible obligation? Because what you think you are talking about, what you are expressing in writing, and what you are going through in your head may be 3 different things going on at the same time. And when you are expressing an idea or an opinion to another party, you must make sure that they are on the same wavelength that you are on. I've seen pleading after pleading written by attorneys, written by paralegals. They sold John Doe's loan. MERS assigned the mortgage. I mean, if you're not specific, how is the judge to make a determination as to what was done in accordance with law? So these are my definitions, because I'm beat over the head every day with being as specific as I can. So these are not substitutes for legal definitions provided by appropriate legal counsel. These definitions are provided to offer a general understanding of terms. A mortgage loan is a loan secured by real property through the use of a tangible promissory note, which evidences the debt and the encumbrance of property rights through the granting of a mortgage or deed of trust, which secures the loan. However, the word mortgage in everyday usage is most often to mean mortgage loan. Again, we need to be specific. What are we talking about? Mortgage? Are we talking about mortgage loan? You need to have an understanding. Most people don't They just speak, and they assume that everyone is on the same wavelength that they are. That does not always work. Tangible promissory note. A tangible promissory note is a piece of paper that can be touched, that contains the promise to pay. But the real significance is not the physical paper, but the legal rights which the paper confers. And hence the promissory note is defined by the legal debt. The note is a tangible negotiable instrument that evidences the intangible obligation. Security instrument. The mortgage or deed of trust is seen as a real property lien if filed of record, and it is a separate contract listing an alternative means for collecting payment due under the intangible obligation evidenced by the tangible promissory note. That's what it is. Your security instrument is an alternative means of collection, period. It's a unilateral contract that was written up by your lender. You just were told, sign here, please. Only 85 more pages to go. The entire instrument we talked about earlier is comprised of both documents, a tangible promissory note and tangible security instrument, which would either be a mortgage or deed of trust, along with the intangible obligation. For there to be a right to enforce any part of the entire instrument, all three parts, tangible and intangible, must be named to the same party. In the case of the tangible security instrument, named in public record, and in the case of the tangible promissory note on the document itself, and in the case of the intangible record, in the transferable record. So, for the security instrument, you need to be named in public record. For the tangible promissory note, you need to be named to the note, either as lender or as payee. And in the case of the intangible obligation, that would be reflected in the transferable record. Tangible obligor. Majority of the time, this is the homeowner, the party whom signed the tangible promissory note, the tangible obligor. The tangible obligee is the party whom is named on the tangible promissory note as either the lender or is properly named as payee on the payee line, physically affixed to the tangible promissory note. Again, tangible obligee, lender or named as payee. Intangible obligor. Now, this is the party that creates the intangible obligation using the intangible payment stream of the tangible promissory note. So, they're not talking about the homeowner. Many times we're referring this to 3-102 under definitions of the account debtor. All right? Because what happens many times is we have a third party, all right, that has taken your payment stream. So let's say that I have a note and I'm with John Doe or Billy Bob Mortgage Company. All right? Billy Bob sells that obligation. All right? And they do this through negotiation, transfer, delivery of the note. And they sell it to, say, Wells Fargo. All right? Wells Fargo now has this tangible obligation. They've also done an assignment to Wells Fargo like they're supposed to. All right? And Wells Fargo says, hey, I'm going to sell this. I'm going to sell it to Fannie Mae. Now, Fannie Mae purchases it, that intangible obligation, from the intangible obligor. So they are using the payment stream, I promise to pay, $1,000 for the next 360 months. They're selling that payment stream to the intangible obligee, the party that purchases it. All right? Now, to give you an example, if one were to just go back and check a couple of cases, one of them being Kemp versus Countrywide. And this is a very good case because in the deposition of Lindy DiMartini, I believe it's on page 14, that she states, Countrywide is in the business of selling beneficial interest. Countrywide is not in the business of selling notes. And what she was stating was very true. They're selling those promises to pay. And the intangible obligee is a party that purchases the intangible obligation from the intangible obligor. They're seldom filed of record as a secured party to the tangible obligor security instrument. So on the RMBS secondary market, sales are being made every day, and yet we don't see anything on the note. We don't see anything filed in public record. So when you understand, who is the intangible obligee? Who was the intangible obligor? Well, that was the account debtor. Many times the intangible obligor is also called the depositor if you're in an RMBS trust, residential mortgage-backed security. Here we go to the actual definition. Account debtor, UCC Article 9, secured transactions. Account debtor. And I just skipped through so we don't have to read all of this, but basically when you go down to section 3, it goes to account debtor. Account debtor states, account debtor means a person obligated on an account, chattel paper, general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. So, meaning, they're not talking about the homeowner. I'll use me for an example. So we bought a house, took a loan out, and interest of that loan was sold to Fannie Mae from Countrywide. Well, I'm obligated to pay on the note. All right? Now, a third party, being Countrywide, for example, sells that obligation to Fannie Mae. Fannie Mae didn't purchase a note. Fannie Mae just purchased an obligation created from my payment stream. All right? Fannie Mae is not named to the note. Fannie Mae is not named in public record. What does Fannie Mae purchase? They've purchased, all right, an obligation, an electronic intangible obligation or transferable record that was created using a note that I signed. I don't have any agreement with Fannie Mae. So now, let's say I go to bankruptcy and I've discharged that debt. Now there is no debt attached to that note. But yet they say Fannie Mae is a secured creditor. Wait a minute. Secured to what? I've not contracted with them. So we need to understand who is the account debtor. Means a person obligated on an account. So when we go back to the intangible obligor, this is the party that's creating an intangible obligation. So using your payment stream, being the homeowner payment stream, they're going to create an obligation, and they're going to sell this transferable record using an e-note, an e-mortgage, all right? However, there is no laws that pertaining to the negotiation of electronic instruments, only real property, So, again, we're going through a lot of stuff. We're talking about MERS, okay? MERS is Mortgage Electronic Registration Systems Incorporated. MERS is a wholly owned subsidiary of MERS Corp. And serves as a mortgagee in a nominee capacity. Again, just as a nominee capacity, period, for the lender and subsequent assignees. All they do is have an electronic database that is used to track the intangible obligation as well as the servicing rights. They do not operate in the tangible world. They operate in the intangible world. If we were to take a look at a milestone report, all right, all they're talking about is, what are they talking about? Electronic notes. We talk about here in this particular one, all right, registered. They've registered the records, all right, because that's what they do, registration. They don't record them, they register them on their database. All right, so they registered it. It's active, all right? They registered it 10:05, all right? A month later, they've released the interim funder's interest. Okay, again, 2, transfer of beneficial rights. They did that in 06. All right, transfer of servicing rights. There is nothing in here showing that anything is recorded. All they're talking about is servicing rights and the intangible obligation. That's it. They're talking about servicer, new investor, old investor, new servicer, foreclosure status, assigned to servicer. So milestone reports, all they talk about is electronic filings, electronic records, transferable records. We're going to take a short break for about, let's take a break for 15 minutes. So stretch your feet and grab another cup of coffee, grab some more water, take a quick restroom break. And we come back, we're going to jump into MERS for a little bit. And we need to have an understanding of just what it is in MERS and what it is that they transfer. And then we're going to go into more statutes. We're going to go into Federal Civil Procedure. We're going to go into elements for summary judgment, motion to dismiss. And we have a lot more work to cover. So again, let's take a quick break for about 15 minutes and we'll come back. And I look forward to everyone again. Thank you. We're going over a lot of stuff.
Yeah. Good though.
It's
What's that clank? Did you drop something?
the glass.
Hi, I'm Jason and welcome to Fraud Stoppers, the company dedicated to fighting fraud closures. We find ourselves living in a time where banks and mortgage lenders have been caught red-handed, engaged some rather nefarious practices like committing mortgage and appraisal fraud, creating fraudulent loan and foreclosure documents, robo-signing fake and forged signatures, deliberately losing homeowners' paperwork and documents to foreclosure, destroying vital loan documents to cover their tracks, paying bonuses to employees for denying loan modifications out of hand so they can illegally foreclosure on innocent homeowners, sometimes making many times their original amount of the loan in the diversities market through credit default swaps and other illegal pyramid schemes. You may find yourself in a situation with Countrywide, Bank of America, Chase, Nation Star, Wells Fargo, HSBC, or maybe one of these companies. If so, there is a good chance your loan contains error, legal violations, breaches of contract, and fraud.
Winston Wallace, Fraud Stoppers Paralegal Department. According to an FDIC audit, over 80% of mortgage loans contain legal violations, contract breaches, errors, and fraud. Did you know if there's fraud in a contract, like your mortgage and loan, then the contract could be declared null and void? And on top of that, the victims of that fraud could sue for financial compensation, their property clear and free, or even better. In fact, in a fraud case, you don't sue for what you were defrauded of, no! Instead, you sue for a whole lot more, like punitive damages. That's what Kimberly Thomas in Baltimore did. She sued Wells Fargo for fraud, and her 6-person federal jury awarded her $1.25 million in financial fraud claim damages. $1 million in punitive damages just because they wanted to spank the bank. You can read about her case in our blog page and a whole lot more.
Hi, I'm Terry in customer service. Listen, if you're having difficulty with your mortgage, you're facing foreclosure, your foreclosure sales date is approaching fast, or your foreclosure sales date has already passed, we can help you with these products and services. Stop foreclosure sale, reverse foreclosure sale, loan modifications, quiet title lawsuits, wrongful foreclosure lawsuits, foreclosure attorney network, pro se products and services, securitization and mortgage fraud audits, expert witness affidavits, short sales buyback programs, private investor refinance programs, and more. So whatever your situation or desired outcome happens to be, don't worry, Fraud Stoppers has you covered. So call anytime.
Now, I'm sure you're looking for the most affordable and effective options available, correct? No worries, we've got you covered. With our easy non-credit-based financing and affordable payment options, you can fight foreclosure without breaking your bank.
Hi, Esther Goldberg in the sales department to celebrate Fraud Stoppers National Launch. We're having a sale with deep discount prices and special financing offers. We're talking about saving you some serious loot, baby. But I have to warn you, you better hurry because this party won't last forever. So what are you waiting for? A personal invitation? Well, you got it. You're invited. Now, would someone please get me another martini? It's happy hour.
Getting started is easier than inviting Esther to the company Christmas party. Just go to www.fraudstoppers.org and click the Get Started Now button right here. Then just fill out this form, click the Submit button, and one of our agents will contact you right away to conduct a free, confidential fraud analysis to help you determine what your best option to saving your piece of the American dream is. It's as easy as that. Then stick around and watch some of our other videos. I'm sure you will see something interesting. Until then, thanks for watching and have a great day.
Hi, I'm Mary. And I'm Jennifer. Are you looking to save your house from foreclosure using the help of an affordable and competent attorney? Or are you thinking about doing it yourself? Pro se, so you can save money in legal fees? Or maybe you want a combination of the two, so you can save money and get the help you need. Whether you're looking to stop your foreclosure sale, reverse a foreclosure sale, negotiate a loan modification or short sale, sue for quiet title or wrongful foreclosure, Fraud Stoppers has what you need. Now you can take advantage of our nationwide network of foreclosure attorneys, realtors, investors, pro se products and services, this with our easy, non-credit-based financing and affordable monthly payment plans. Plus, we're having a huge sale to celebrate our new products and services. Getting started is easy. Just take a second and click the Get Started Now button. We'll call you right away to help you find an effective and affordable way to save your house. But don't wait too long, because in foreclosure, the sooner you get started, the more options you have. So get started right now and register for your free consultation. Get the help you need to save your piece of the American dream. Until then, take care. Bye.
Okay, everyone, welcome back. We're going to be going over a little bit on MERS, and the reason is I'd like everyone to have a little better understanding of MERS. When I look at MERS as being an iceberg in the middle of the ocean. And when we look at an iceberg, we only see about 10% of it. What you don't see is 90% of it that is below the water. So I'd like to go over MERS a little bit in depth and as to what it does and as to what it does not do. A few of these subjects that we've gone over already, so we're just going to skirt by those issues. But let's just take a look as to when we're talking about MERS. Okay, so MERS. MERS is Mortgage Electronic Registration Systems Incorporated. Oops, I apologize. Wrong button. All right. So this was started in 1993. Right. We had Angelo Mazzillo, who was at that time the president of the Mortgage Bankers Association, and he was also the president and CEO of Countrywide Funding Corporation. He headed up a task force and a committee. And this committee consisted of a lot of the big shots, such as William Calavie. He was the Chief Information Officer for Fannie Mae. Paul Peterson, he was in charge of the servicing for Freddie Mac. We had Kenneth Tucker. He was the Deputy Director of the FHA. All right. You had Michael Daly, who was a Ginnie Mae Special Assistant. We had Warren Lesko, who was the Mortgage Bankers Association. So MERS was set up years ago. It was set up because of greed. They were looking for a way to make more money, make more profits, hide information. So all of the big boys were involved in it. This isn't something that they just decided, well, let's just start it. They started, again, 1993 is when they started initiating a task force on this. MERS does not go to the tangible promissory note. We went over the definition of tangible promissory note. MERS does not track the paper promissory note. MERS only tracks electronic obligations, or e-notes, which are registered on the MERS e-registry. MERS is electronic. So again, we went back, we showed you the MERS milestone. That tracks electronic servicing rights, electronic obligations, electronic e-notes. That's all the MERS system does. MERS is limited to electronic notes and not paper notes. Okay. Now, when they set up MERS, right, the National Registry is intended to satisfy the requirements of UE-ETA and e-Sign. UE-ETA is the Uniform Electronic Transmission Act, and e-Sign is the Electronic Signature Instrument, electronic signatures for electronic notes only. All right, now, they wanted to use e-Sign and they wanted to use UE-ETA And they were saying that, oh, you know what, it applies. But they couldn't, because e-sign and UE edit do not apply to Article 3 or Article 9. So they could not use the electronic signatures, all right, for electronic notes. So the function of the MERS registry is a system that electronically tracks transferable records, all right, that are created, generated, sent, and communicated, received, or stored by electric means. So that is not the tangible promissory note that you signed. So we need to understand it is just a registry, period. Their function is to electronically track transferable records. Transferable records, all right, are related to personal property, not real property. So when you're looking at it, you're like, wait a minute, that's not what I thought. All right. When we look at the e-notes, all right, the e-notes, all right, are private labeled secondary electronic obligations called transferable records. And they're governed by 15 U.S.C. Section 7021 and Section 322.016 and or possibly by your state's equivalents to 9.105. Again, they're secondary electronic obligations. That is what an e-note is. It's a transferable record. All right. What is a transferable record, Joe? Well, let's see. A transferable record is an electronic-oriented obligation governed by 15 U.S.C. Section 7021 and Section 322.016. It is not a direct obligation of an underlying real property mortgage loan. Transferable records, A in this section, transferable record means an electronic record that would be a note under Chapter 3 or Article 3 or a document under Article 7 if the electronic record were in writing. It says if, but it is not in writing. It's electric. It's a record. And two, the issuer of the electronic record expressly has signed and agreed or has expressly agreed is a transferable record. It's not the same. It's just a transferable record. It is not a note under Article 3. Period. Electronic records are different. Transferable records. It is not the same as your tangible promissory note. All right. The function of the transferable record is an electronic equivalent. Again, it's an electronic equivalent. It's not the same. They lead you to believe that it is of a negotiable instrument, but it is only used in the electronic world of e-mortgages. A transferable record is not a UCC Article 3 negotiable instrument. Again, step back, take a look at it. What is it? Wait a minute. They said they're transferring the note. They transferred an electronic note, not a tangible promissory note. Well, they talk about the e-mortgage. A copy of a tangible contract that evidences an alternative means of collection when there is a default on the payment intangible. The big thing to notice here is that it is an alternative means of collection. That's it. All right, now to properly negotiate a lawful secured indebtedness up to Wall Street or to Fannie Mae and Freddie Mac, you need a paper promissory note, negotiable instrument, along with a valid, perfected paper security instrument. Naming MERS as nominee does not meet the definition of the lender naming MERS as beneficiary. And as such, naming MERS as beneficiary bifurcated the paper security instrument from the paper negotiable instrument at the moment of conception. We know that electronic documents lack supporting laws to exist. And I'd like to just, while we're talking about this right now, I just happen to have something, and I know where it's at. So let's look at here. I think this is it. Let's see, pages 28, 29, and 30. Bear with me for 1 second. Okay. This is from a ruling, Baines versus MERS, and this is from the state of Washington. Okay. And I again, it just happened to have it in MERS, so I'm going to bring it up now. Where the courts have said, we have answered the first certified question, no. Based on the plain statute, MERS is an ineligible beneficiary within the terms of the Washington Deed of Trust Act. This is for the state of Washington. If it never held the promissory note or other debt instrument secured by the deed of trust. So for the state of Washington, all right, MERS does not fit the beneficiary. In the alternative, MERS suggests if we find a violation in the act, MERS should be required to assign its interest in any of the deed trusts to the holder of the promissory note and have that assignment recorded in land record before any non-judicial could take place. But if MERS is not the beneficiary as contemplated by Washington law, then it is unclear what rights, if any, it has to convey. So we've got court orders that say, hey, wait a minute. MERS doesn't meet, just because they say they're a beneficiary, that doesn't make anything. Again, until you dispute it, your acquiescence just accepts it. Okay. We talked earlier about the UETA, Uniform Electronic Transactions Act, all right, 1596-1-7003 states specific exceptions to this UETA ruling. The provisions, accepted requirements of Section 7001 of this title shall not apply to a contract or other record to the extent it is governed by Section 3, the Uniform Commercial Code, as in effect in any state, other than Sections 1-107, 1-206, Articles 2, and Articles 3. So when they're attempting to apply UETA and e-sign to these transferable records, we have a law that says it can't happen. The above noted exception clearly states e-sign does not govern electronic negotiable instruments or electronic security instrument. All right, the fact is that UCC 3, I'm sorry, I have UCC 4, it's UCC 3, was in a hurry when I typed, governs paper negotiable instruments and the paper security instruments. UCC does not provide supporting law for the use of any electronic negotiable instrument or an electronic security instrument. All right? Therefore, any attempts by the banks to utilize UCC as a legal authority for e-notes, all right, is not going to work. All right? It's misplaced. You cannot apply UCC to transferable records. It doesn't work. All right, this is a definition that the Mortgage Bankers Association came up with e-mortgages. We define e-mortgage as a mortgage where the critical loan documentation, at a minimum the promissory note, and preferably also the security instrument and other closing docs, are created electronically, executed electronically, transferred electronically, and stored electronically, aka the paperless mortgage. So that's what an e-mortgage is. They're created electronically. You didn't sign anything. You have a unilateral contract that was written by a lender that the homeowner signed. Same thing for the security instrument as well. The electronic transferable records are created by a third party called the account debtor. Okay. MER's greatest role is that of the security instrument. Now, so just to clear the air, so I want to explain to everyone, when I put the verbiage within the analysis and in my investigation that I do, I've got the Freddie Mac, Fannie Mae books. All right. Now, on page 12 of the Freddie Mac e-mortgage guide version 2.0, it states, seller servicer must also comply with the applicable purchase documents and make the representations and warranties in this e-mortgage guide, including without limitation that any e-note sold to Freddie Mac will be valid and enforceable, and that the other electronic records created, provided, signed, and otherwise processed using the e-closing system were so created, provided, signed, or processed in compliance with applicable state and federal law. This is Freddie Mac's get out of jail free card, because within their e-mortgage guide version 2.0, they're stating that the server seller, all right, it must be in compliance with applicable state and federal law. Now, just because they did not hold their feet to the fire does not make it any less applicable. This is what they were. If you were going to the cash window for Freddie Mac, was it created in compliance with law? Yes or no? It says it's supposed to. I don't make these up. This is what they state. All right. Let's go to Fannie Mae for a minute. As stated on page 5 of the guide, Delivering E-Mortgage Loan to Fannie Mae, version 2.5. Paragraph 2.1, Overview. An e-mortgage is a mortgage for which the promissory note and possibly other documents such as security instrument and loan application are created and stored electronically, rather than by using the traditional paper documentation that has a pink and ink signature. Because of the limited number of recording jurisdictions that accept electronic documents for recordation, most, but not all, e-mortgages typically consist of a paper security instrument and electronic note, hence e-note. As stated on page 5 of the guide to delivering e-mortgage loans to Fannie Mae, version 2.5, paragraph 2.2, Initial and periodic assessments. Each lender is responsible for determining that it meets the legal, technological, and other operational requirements necessary to create valid and enforceable mortgage obligations. and that it otherwise complies with our requirements, which in some cases may be in addition to minimum statutory requirements. So it's stating that each lender is responsible to determine that it meets the legal, technological, and operational requirements necessary to create valid and enforceable mortgage obligations. I didn't make this up, people. They put this in their governing documents. I happen to have copies of all of them. When we created our infographics, all the verbiage that we state, I cite the source. In some cases, it took me months to get the correct source. I knew the information, but I'm able to back it up. This is where it came from. This is what it said. Here's the page. Prove me wrong. E-notes pertain to personal property, not real property. So when we're out and we're looking at the big picture, now you're saying, okay, well, that's a lot of damaging stuff, Joe. All right, now I've got a little better inception of what MERS actually is. Here is information that is put out by MERS. I couldn't make this up if I wanted it, people. MERS Basics. Again, you see the MERS logo down there? Put out by yours truly, MERS. Registration versus recording. The MERS system is not a system of legal record, nor a replacement for the public land records. Mortgages must be recorded in the public land records. Bullet point 2, tracking versus transfer. The MERS system is a tracking system. No interests are transferred on the system, only tracked. Wow, imagine that. Let's go look at this. MERS definitions. Paper world, electronic world. Paper world, we have possession. Electronic world, we have control. Paper world, original note, wet signature. Electronic world, authoritative copy of e-note. Paper world, investor. Electronic world, controller. Paper world, custodian. Electronic world, location. Paper world, endorsement. Electronic world, transfer of control. Paper world, holder in due course. Electronic world, transferable. Record audit trail. People, they are not the same. Night and day difference. All right, key assumptions used in development. Again, this is put out by MERS. Industry investors will require e-note registration. E-notes must refer specifically to the MERS e-registry. Participants must be members of MERS. Registry does not store e-notes. Multiple e-vaults will be created to store e-notes. Funding of loans occurs outside the registry. It's everything that we're saying, people, except this is, MERS is backing up what we say. What is the difference? Create an e-note in a smart doc format. Execute an e-note with digital signatures. Store an e-note in a compliant vault. Deliver the e-note to the investor. Transfer the e-note from one vault to another. Service e-note. They're not servicing your note, they're servicing the e-note. Interface with MERS e-registry to record these steps. Big difference than what they're to do in the paper world. Night and day, but yet they lead you to believe that what they're doing is being done in compliance with law. It may be lawful in their mind, but it's not legal. The acquiring of rights must be done in accordance with law. These are e-notes in the mortgage process. Again, a big difference between what was to be done in the paper world and what is done in the electronic world. So when you're, again, stepping back, you see there's a lot more going on electronically that you didn't see. When we look at the county recorder's office, that is to the side of MERS, right? You have MERS right there, all right? Registry. This is the county recorder's office, all right? When you look back, it says MERS is not a party to the note and has conferred no rights. One cannot assign what one has never received. We've created a few charts. This is what took place prior to 1997. 1997 is when MERS acquired the first set of property started going in. So if you take a look and you look at all of these parties to the transactions, the borrower, the lender, the originator, the sponsor sale, the depositor, the trustee, the RMBS trust, those are in blue. And then you notice in green we have the note, in gray we have the security instrument, in purple we have the assignment, yellow we have parties to the transactions that are indirect. And when you look at the arrows, all right, you see the transfer of money. The gold is the transfer of services. The purple is the transfer of the documents. And you look at all these transactions that are taking place and look at all the recording fees that takes place. If you had a loan that was done prior to 1997, and many of us did, this is how it was done. And the average time from Party A to Party D, or Party E, or Party F, was approximately 120 to 180 days it took. However, when it was done prior to 97, all right, prior to the implementation of MERS, when that negotiable instrument was sold, transferred, and delivered, at the same time that intangible obligation was sold, transferred, and delivered, the trust was not created until it got all the way down to the end, when the assets went in it. Big difference today. Okay, this is what the banks were looking at. Waste of time, waste of money. Oh my God. You know what? I need to make more money faster. Electronically, we can do it. So they made a determination that we can cut out time, we can save money. We can make more profits. And that's what happened. So they made cuts. And it's a big difference because the transactions that were to take place suddenly are not happening. So now when we look at, this is what the banks are actually doing. Wait a minute, Joe. That didn't look like the first slide with all the different transactions. All the different recording fees taking place? No, that takes time. That takes money. We're just going to cut out and we'll just do a couple of them. A big difference. What takes place nowadays, all right, is that they are sidestepping statutory requirements of law. So we need to have a better understanding as to what the law says. What is Party A transferring? How are they transferring? What is the purpose of the transfer? Again, MERS is not a party to the note and is conferred no rights. One cannot assign what they've never received. If MERS has been conferred, all right, the right to register, fine. That means they can only transfer that right to register. That's what it says. You're in a nominee, you're in an administrative capacity. Well, then you can only assign that administrative capacity. Period. Take a look. It pertains to title, people. It all breaks down to title. We talked about it before. What is title? We've been through all of this. So when you look at MERS again, all right, MERS registry holds a list of parties who should have been in the chain of title as secured parties, but the first subsequent intervening party failed to permanently perfect their interest of record pursuant to 9312. All right, and as these intervening parties bought and sold the interest, and many times it was within a day, they were all under the belief that they had a perfected interest because it's on the MERS registry. And that's why they said, well, it's in an RMBS, residential mortgage-backed security. No, it's not, you dummy. It's just registered. It's not recorded in public record. It's not timely pursuant to statutory requirements of law. So, gentlemen and ladies, this is why MCI is on the lookout for foreclosure crimes. So, with that, we're going to proceed. Again, this is MCI, and this is my interpretation of MERS. So let's just escape. Give me 1 second. All right. So let's continue. Give me a second. Okay. Got sidetracked for a minute. All right. I'd like to talk for a minute. All right, now that we've got an understanding of statutes, we have an understanding of MERS. All right. You hear me talk about in the investigation about a 424B5 prospectus. You hear me talk about a pooling servicing agreement. What are those? Those are governing documents created by the entity that creates a trust. The pooling and servicing agreement is one of the documents. It's legally binding. It determines, all right, what is it, what are the rules that the entity needs to follow? Let's do this. All right, so bear with me for a minute. Here's one that I've highlighted a while ago. This is a prospectus supplement, but if you just bear with me for a minute, let's just pull one up. Okay, 2000 Thanks for being patient. Thank you. I'm going to pull up the pool and servicing agreement. Trust. Okay. Should be this. Distribution report. This is it. One second. I'm just trying to see if I can locate the PSA that matches this prospectus supplement that I highlighted. Thank you for being patient. Let's see if this is it. Okay. Okay. What this is, for a second, just so you can have a quick look. When I look at a pool-in servicing agreement or a 4B5 prospectus, many times I look at the free writing prospectuses which have the loan data information in addition to the databases that I have access to. All right, we also double check many times to see if I can locate the instrument. So this gives the loan number. All right, this talks about the date of the loan, when it expires, maturity date, negative amortization. This is the unpaid balance. This is the doc type. What did you have, a full documentation? So many times this information is in the free writing prospectuses, and it has all the information. It has a lot of information, and many times these are over 1,000 pages. So just a quick idea. That's what I was looking up. But anyways, all right. So the pool-in servicing agreement is one of the documents that governs the trust. The other one is a prospectus, 424B5 prospectus, pursuant to the Securities Act of 1933. Now, in that information, all right, it tells you, it says to here, this is a prospectus supplement to prospectus that is dated November 14, 2006. And it tells the parties to the transactions. Well, this is the depositor, C. Walt. The sponsor and sellers, Countrywide Home Loan Servicing, LP. Issuing entity, Alternative Loan Trust, 2007-J1. All right. So this gives information within the prospectus. All right. Who are the parties? What were they supposed to do? What are the rules and regulations? All right. What laws are they governed by? So all of that information follows the prospectus. So as you go through the prospectus, all right, give me 1 second. Okay, you can see everything that is in there. So I've just gone through it. I've gone through, when I'm going through the prospectuses, what I'm looking for. So this is a great educational piece. We talk about material tax consequences, prohibited transactions, index to defined terms. Now what I've done, again, is gone through and highlight many of the things that I look at. So when one is understanding, well, Joe, you sent me back a PSA, what's in it? Well, there's a plethora of information. You just need to go through and read it. Now, the one that I've highlighted is not necessarily yours. This is just a boilerplate templated one where it talks about the parties, issuing entity. All right, common law trust formed under the state laws of state of New York. Oh, good. So now, Joe, you're telling me that this is governed under state of New York, and under state of New York, all right, now I can use trust law for state of New York. All right. There's a depositor. Here's sponsor and sellers. All right. Here's the pooling servicing agreement, all right? There's one for that. Here's a trustee. Here's a cutoff date. Here's the closing date. All right, so the cutoff date says for any mortgage loan conveyed to the issuing entity on the closing date, the later of February 1st, and the date of the origination, the initial cutoff date. All right, for any mortgage loan conveyed to the issuing entity after close date, the latter of the origination date, and the first day of the month to the conveyance of the issuing entity. This is the date they started, opening it up. Here's the date it closed. Started February 1st, closed it 28th. So we need to start understanding what is the information in here. Now, what I've done, and I will send anyone that requested a copy, is I've gone through this particular trust, and again, for educational purposes, I've broken it down. Here's an index. P1, basic information. PS2, table of contents. PS3. And as you go through it, you can understand there's a lot of information that is in here. So these are the pages. All right. And here's how you use it. I'll give you a set of instructions if you request. And the instructions are going to tell you how you are going to print out, all right, all the pages for the 424B5 prospectus right here. All right, and what you're going to do is you're going to get a 4-inch D-ring binder, and all the information is included as to how to use this. All right, and it talks about printing out the index, all right, that I've made, and getting yourself a packet of the signature tabs, like when you sign a contract and you have the little signature tabs with the arrow, and you're going to get yourself a Sharpie. So you're going to print out all the pages of the prospectus. You can get a 4-inch D-ring binder. You're going to put them in it. And then you're going to get a set of index tabs or signature tabs and a Sharpie, and you're going to print out this table of index. All right, and a table of index, all right, is right here, and you're going to lay that to the side. So what's going to happen is that you're going to have the binder over here on your right and the index on your left. And you're going to say, oh, okay, I need to go to page 1. Okay, so the prospectus says page 1. Here's page 1. And you're going to put a little tab and write in Sharpie, PS1. And you're going to do that. Next one says, okay, I'm supposed to go to page 2. Next one, PS3. The numbers are at the bottom. S2, S3. All right, so all the pages are numbered. So as you go through this, okay, you're going to have a completely indexed 424B5 prospectus. Now, once it's indexed, you can go to the top, to the bottom. Go to the top, go to the bottom. So by the time you get down to the bottom, you've got a fully indexed educational prospectus supplement to go through. You don't have to read every page. Go to the pages that I've highlighted. Again, it'll give you a basic understanding as to the items that are in this particular prospectus. Is it yours? No. Is it comparable to yours? Yes. I mean, if you want to do yours, you can do yours. All right? You can also do Control F, and you can put in, again, whatever you're looking for. You can do word searches. So, again, this is an educational piece that is invaluable in understanding, all right, what goes on in a 424B5 prospectus. What is going on in the pooling servicing agreement? So again, this is just something we need to have an understanding as to the documents that we're looking at. All right, if the pooling servicing agreement is one of the governing documents, then we need to be clear. They're going to claim you are not a party to the pooling servicing agreement. Correct, I'm not a party, but you know what? You claim to be a party to it. And if you are a party to it and you did not comply with law, then you violated law. Period. Are you saying that you're governed under New York trust law? Yes or no? Yes. Okay. All we're doing is holding your feet to the fire. All right? If you did not do the transactions that were stated in the pool and servicing agreement, you have not acquired rights. You have not been in accordance with law. You have not acquired rights, all right, to become Pete, person entitled to enforce. Again, people, it's all about rights. All right? So it's just something to understand. I'd like to go into now, break away from this and go into a little bit of Federal Rules of Procedure. Because, well, before we do that, let's go back into, all right, so we've gone from MERS, we've gone through declaratory judgment a little bit. The reason for declaratory judgment, again, is because I've seen all of these quiet title actions, and quiet title is a good action if done in accordance with law and if done timeliness. And as a matter of fact, I've written a few articles on it. I'd like to go over them so I can give you an understanding as to when and where, all right, quiet title is appropriate. Because quiet title is like yin and yang. There's two faces to quiet title. Quiet title is a cause of action, and quiet title is a form of relief. And in order for us to do our declaratory judgment for a suit to quiet a cloud on title with rescission of an assignment of mortgage or the rescission of an assignment of deed of trust that was done or that was ineligible to be recorded, we need to understand, okay, why is my quiet title not timely to file? Why are we looking at a different action to take? All right. Now, those actions, you can take any action you want, but the problem is that they're being remanded to federal court in many cases. All right. And the quiet title goes nowhere. All right. So what we're saying is, hey, let's look at something else. All right. Let's look at, all right, do you want a house of straw or a house of built of bricks? All right. And we're going to go over it because I think it's appropriate. This is an article that I've written, and you can read it with me. I'm not sure, again, if many of you have seen it, but I want you to have an understanding of what I'm talking about. So you can read it with me. Let's go over it, and then we're going to discuss it, and then we're going to go into two more articles, and then we're going to go into Federal Rules of Civil Procedure. All right, house built of straw or a house built of bricks. Laying the proper foundation is essential before one can begin building upon it. This applies to almost everything in life. It is no different in issues pertaining to foreclosure, whether going on the offense or defense. When one desires to start building, they need to make a determination as to what ingredients to use. Should I use straw or bricks? In a foreclosure action, declaratory relief should be considered a brick and is a good start.
Four, get my shoes and out the door. 5, I'm alive. 6, 7, 8, feeling great. 9, gonna shine, life is good. I'm doing fine, 10, gonna do it right and do it again, yeah. I look into the sky with all the beautiful color, but there's more than just for me, so gonna share it with another. I got to show, to give, let out. I want to sing and shout. Take a look and see a beautiful morning that turns into a beautiful evening, and together make a beautiful life. And if you wanna see, then come along with me, that's right. foundation of consistency. Come on, say oh.
A declaratory judgment is a judgment of a court which determines the right of parties as well as establishing status quo. Unfortunately, it is not used as much as it should be in this writer's opinion. It's my opinion. Many times this action will resolve some or all the issues in the matter at hand. This determination refers to the parties' rights of issues presented. Once this is done, then one can proceed with injunctive relief. This type of relief can take place in many different forms, such as temporary restraining orders, preliminary injunctions, and permanent injunctions. Injunctive relief is a very powerful remedy that can be used in regards to a specific behavior. An injunction would be considered an equitable remedy in the form of a court order. Injunctions are orders that are made by courts either restraining or requiring performance of a specific act in order to give effect to the legal rights of the applicant. Among the elements which must be proven by the party seeking the injunction are: 1. It has no adequate remedy other than an injunction, such as money damages. 2. Truly irreparable harm will occur in the absence of an injunction. 3. That it is more likely than not that the moving party will prevail on the underlying merits when the matter ultimately goes to trial. 4. The benefit to the party seeking the injunction outweighs the burden of the party opposed to the injunction. And 5. The moving party's right to relief sought is clear. All right. Many times the courts have enjoined the trustee sale for a property with a presumed deficiency with an injunction prohibiting a sale. So many times they have stopped sales using an injunction. All right. Now, enjoin, as defined at the Merriam-Webster Dictionary line, states, to direct or order someone to do something, to prevent someone from doing something, especially to give a legal order preventing someone to do something. So if we get an injunction, all right, again, you can use an injunction correctly, all right, to prevent someone from doing something, all right. Many times we do not do it correctly. If we do it correctly, all right, we can have a strong house and not just a house of straw, all right. But again, in my opinion, if we were to go for a declaratory judgment first, right, get a judgment of the court which will determine the rights of everyone before going to take an injunctive relief. So if we go forth and they get a court's determination that Bank of America has not acquired rights, all right, to this property, and we get an order stating that Bank of America then cannot come forth later on to do an action. We must strive to build a strong brick house and not a house built of straw. The house of straw is just, where we're just taking items and throwing enough mud against the wall hoping something sticks. All right? So before we do anything, in my opinion, we need to look at what is it we're trying to do and what is the best goal, or what is the best way to achieve that goal. All right? For me, I see quiet title as a viable action to take. All right? But I'm looking at declaratory judgment. All right? And then when using declaratory judgment, using res judicata. All right? Now, res judicata means that matter judged. Res judicata is the principle Here's another article I've written. I'm sorry. All right. All right. Res judicata is the principle that a matter may not be relitigated once it has been judged. All right. So if you have additional issues that were not brought forth prior to the case being adjudicated on the merits, you'll be barred from bringing forth any additional errors. How about if we use declaratory judgment, all right, have them rule on the merits, and now with them getting a ruling on the merits, now it's been adjudicated. Now no more issues can be brought forth because you are going to stop them using res judicata. All right? Now, in my opinion, if you're going to go forth with anything, you either do all or you do nothing. Many times people will hold their cards close to them thinking that they're going to get an advantage. The problem is that if you do not put all of your cards on the table, all right, you're not going to have a chance to show your cards in the future. All right? So if we understand what res judicata is, and I believe it's a double-edged sword, it can be used for you and against you. All right? But if you do not show all of your cards, then they will not judge all of the issues. All right? It's called claim preclusion. All right? Now, if you're going to come forth and state that a controversy exists between parties, then in my opinion, you should throw everything, including the kitchen sink, at the opposing side. You are not to hold back. You are setting up for your case to go to the appellate court. At the appellate court, you will articulate each and all of the arguments from the lower courts. You will not be allowed to bring forth any new information or arguments. Pursuant to res judicata, you will only be allowed to argue adjudicated matters that have been ruled on from the lower court. Now, let's take this in the form of declaratory judgment. If we were to have a ruling from the courts, say that Bank of America has not acquired rights and that this assignment of mortgage or this assignment of deed of trust was not eligible to be recorded, and that we remove it from public record, all right, we get the court to order that. All right? We get an order from the court stating that they have acquired no rights, and they have no right to claim to title to property. Now they are collateral estoppeled from coming forth with any issues, all right, of claiming a right to title. All right, because once an issue of fact has been determined in a proceeding between two parties, the parties may not relitigate the same issue, even using a different cause of action. Example, if one were to get an order from a state district court where a determination had been made that the document purporting to be an assignment of deed of trust was ineligible to be recorded pursuant to statutory requirements of law, this order from the court would ask that the assignment of deed of trust be declared a nullity and that the lien encumbering this property be removed as well as barring the named parties within the order from any future actions pertaining to title to the property. The parties named in the order would be unable to come forth with any future action pertaining to title, as a determination has already been made based on the merits of law that have been adjudicated. And setting up the issues pertaining to what is to be adjudicated, and the parties that may or may not come play in your sandbox, takes finesse. But if you do it properly, I believe it will leave you smiling. Now, if you are in, say, Florida, right? In Florida, things be done a little different than if one were in, say, California. Okay, so if we were in California, we would do an example of a sample for a declaratory judgment for a suit to quiet a cloud on title with the rescission of an assignment of deed of trust that was ineligible to be recorded. If we were in Florida, all right, in order to do, because we don't try. We do a declaratory judgment. It would be done as a counterclaim. So it would be done as a verified answer or as an affirmative defense and counterclaim for declaratory relief. So there's a couple different ways to do it. But again, we're using statutory law requirements. So now if you take this and you apply it to quiet title, all right, because quiet title is a cause of action, but many times when you come out of the gate and you go file a quiet title action, all right, you're putting the horse in front of, or the cart in front of the horse, and the horse is trying to push and it ain't going nowhere. Because quiet title is a cause of action, all right, meaning that there are certain requirements that must be done statutorily in order to file your statutory requirements of law. One of them is that you cannot have a party with an equitable claim to title, all right, being able to come forth and make a claim. All right, because what happens then is that they remand it to federal court. And when they remand it to federal court, you get hit with the 12b-6. Failure to state a cause of action for which relief can be given. Why? Well, there's somebody that is on title. There's somebody that's got a color of title claim. It's a little different. So when you're looking at quiet title, all right, yes, it is an equitable cause of action, all right, that many homeowners use to identify who may have an enforceable equitable claim to their title. All right, and the reason that many of the homeowners file a lawsuit for quiet title as cause of action is because they believe there is a cloud on the title to their property, and that this action is going to quiet any challenges or claim to the title. That's why the homeowners do it. But it is also an equitable remedy. Now, the remedy which removes a cloud or a possible encumbrance on the title of the real property, all right, that is a remedy. The problem, though, is that in order for the homeowners to receive quiet title as relief, the homeowners must meet their state statutory requirements of law, all right? And most states' requirements require, in order for a quiet title to be granted as equitable relief, that there cannot be an enforceable equitable claim to title the property, evidenced by an obligation such as a properly secured mortgage loan instrument. All right? So, well, wait a minute. There's an assignment. There's a document purports to be an assignment. All right? Well, if there's an assignment, someone has an equitable claim to title. All right? Because the 12b-6 rule, it's designed to screen out cases in which a complaint states a claim based on a wrong for which there is no remedy or a claim can be granted. So if somebody has a claim on your property and you're trying to acquire title action, it's not going to work. They're going to say, wait a minute, I can't give you relief. Somebody else has a claim. And most people don't get it. So in my opinion, quiet title is not to be done as you come out of the gate. Once you get a declaratory judgment as to the status quo of the parties and the determination of rights to the parties, all right, then you can say who can come and play in my party, who can come play in the sandbox. Because until there is a determination as to who has acquired rights and who has not acquired rights in accordance to law, because you have a legal claim to title and you have an equitable claim to title. And out of the gate, that legal claim to title is the superior claim. However, once you have a complaint and now you have controversy, that legal claim to title, all right, takes a junior lien position because it is in dispute. And that equitable claim to title now is being brought forth as a superior claim to title. So one really needs to take a look at what it is that we're trying to do. What is it that we're trying to accomplish? All right. So when we look at Federal Rules of Civil Procedure, again, before you start any action at all, we need to sit down and make a list as to what is it that we're looking to do? What is it that we're looking to achieve? Let's see. Okay, 1 second here. 26. Okay, let's do this. All right, so let's go Rule 12. B. There we go. All right, so again, so what happens many times is that they file a quiet title action, and then it's removed to federal court, and it's based on diversity and a monetary threshold. Threshold $75,000. Diversity meaning that the parties are in more than one state. All right. But now, when you look at it, the purpose of the Rule 12 was to, get rid of these frivolous and baseless claims. So the 12B6A, which is B, right? 12 is the rule, right? Defenses and objections. B says every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. 6, failure to state a claim upon which relief can be granted. So again, when you have not gotten rid, all right, as to who has an equitable claim to your property, you're going to hit that every single time. They can't give you relief because there is another party with an equitable claim to title. How do you get rid of it? Let's get a determination of the courts through a declaratory judgment. Your Honor, I'm not here for damages or nothing. All right? I've been damaged. I no longer have marketable title to my property. With no marketable title to my property, I couldn't sell this if I wanted to. And if I did sell it, I have no idea, all right, as to any of the parties coming forth with any claims if they've acquired rights in accordance with law. Let's look at the claims that they're claiming, and let's look at the law and see if their claims were done in accordance with law. That's it. The declaratory judgment will not stop a foreclosure, but it will give a determination as to the rights of the parties in controversy. So you need to understand how to use it. The best thing is right out of the gate. Make a determination of the parties, all right? Why invite everybody to come to your party and then say, you know what, Burrs, oh my gosh, you don't have any standing. I want to kick you out. Recon Trust, I don't like you being here. I don't think you properly, you're supposed to be substitute trustee. I want to kick you out. How about if before we invite them to your quiet title party, we make a determination of the status quo of everybody that is in the room? And how do you know who that is? Well, let's go to public record. Who has initiated some sort of claim? If we were to go to the deed of trust state, say California, for example, all right, and we can show the courts, all right, that this assignment of deeded trust from MERS to Seawalt Trust, all right, was ineligible to be recorded. And we have all of these things to back up what we're saying. We have the PSA, we have statutory requirements of law, we have everything. All right, and now we get the courts to rescind that assignment, remove it from public record, rescind the lien that is encumbering it. And now we get rid of the assignment of deed of trust. All right, wait a minute. We've got a substitution trustee that was attached to that assignment. Oh, wait a minute. We've got a notice of default election to sell that was attached to the substitution trustee. Oh, wait a minute. I have a notice of trustee sale that was attached to the NOD that was attached to the substitution trustee that was attached to the assignment. Do you see, people, how everything just starts to unwind? And we've had some of these where there's 5 and 6 assignments to the same party. 3 different substitution of trustees. When you untangle the web, when you have an understanding, were these things done in accordance with law? Yes or no? I'm not talking about going to a court of equity and everybody holds hands and sings Kumbaya. All right? This is black or white. Did you do this? Yes or no? If you did, fine. You've acquired rights in accordance with law. I'm out of here. If you did not, what the heck are you doing here? So we need to set up our game plan, everyone, as to what is the end game we're looking at. All right? Because there is no such thing as a free house. There is not. The only thing that there is the loss of an alternative means of collection. So let's just get that straight. The loss of an alternative means of collection. If you did not properly perfect that secured interest in that personal property, all right, that's on you. So once Humpty Dumpty falls off the wall, that's not my fault. They're holding your feet to the fire. If you lose, you're going to lose procedurally. All right, so again, let's take a look at summary judgment. It's pretty interesting. All right, because I hear this time and time again, and even attorneys, they don't follow up. They get a summary judgment and they run and they go hide. But the problem is this, okay? Let's understand, what is summary judgment? All right? Rule 56 is summary judgment. It's a summary judgment procedure. The very mission of summary judgment procedure is to pierce the pleadings and to assess the proof in order to see whether or not there is a genuine need for trial. That's it. Can we just cut to the chase, Your Honor, and bypass 18 months of trial, getting ready for it? That's it. That was the reason for the Rule 56. Summary judgment under Rule 56 of the Federal Rules of Civil Procedure has been a source of controversy and confusion. Some have viewed it as a meretricious shortcut, depriving litigants of the right to trial by jury. Others have seen it as a powerful docketing clearing device essential to the overburdened courts. So depending on what side of the courtroom you're on, depends on how you use it. You can use summary judgment against the banks if you know what you're doing. Right? Any party can file summary judgment. Okay, Rule 56 as a vehicle to implement the objectives of Federal Civil Procedure is speedy and expensive resolution of litigation. little bit of history of summary judgment goes back to 1855. Summary judgment on bills of exchange, sanctioned summary decisions on the merits and actions to collect on bills of exchange and promissory notes. So this isn't just something that was made up, everybody. This has been here since the late 1800s. Okay. What are the elements of a Rule 56? A, defendant under Rule 56, Section B, may move for summary judgment any time. Under Rule 56A, a plaintiff or claimant may move for summary judgment any time after the expiration of 20 days from the commencement of the action or after service of a motion for summary judgment by the adverse party. The 20-day period was intended to give the defendant sufficient time to secure counsel and determine a course of action. Got a spell check there. Okay. A party opposing such a motion may not rest on the allegations and denials of its pleadings, but must set forth specific facts by affidavits or otherwise provided in this rule, showing that there is a genuine issue for trial. So that means if you're opposing the bank summary judgment, you must set forth specific facts showing that there is a genuine issue for trial. The three major elements of a summary judgment analysis. Oh, sorry, this is me, people. This is I needed more information. Okay, issues identifying issues of fact. Okay. The principal issues that arise under Rule 56C. Okay. The principal issues that arise under Rule 56 subsection C are whether or not a factual dispute exists and whether the dispute is material to the outcome of the case and whether the dispute is genuine. Okay. So to preclude summary judgment, a fact dispute must be material. A fact issue is material if it must be decided in order to resolve the substantive claim or defense to which the motion is directed. All right, so stop there. So, a factual material claim. Okay, genuine factual claim. So, if they have not acquired rights in accordance with law, okay, would that material fact would that fact be material for the outcome of the case? All right. That's the question that the courts would need to assess. All right. If you're saying, well, we've got genuine issues of material fact. All right. They have not acquired rights. All right. You now shift by stating those facts, all right, that they're genuine, they're material, all right. Now the opposing party is going to have to overcome, and now you've switched the burden of proof to them. So anytime there's a summary judgment, you need to answer it. You need to disprove that summary judgment. You need to show that there's, hey, wait a minute, we've got a dispute here. We've got genuine material facts. And you must look at these facts before a determination can be made. If this goes to trial, our genuine issues of material fact will show that we will prevail in trial. And that's what you must show in order to overcome the summary judgment. To preclude summary judgment, a fact dispute must be material. A fact issue is material if it must be decided in order to resolve the substantive claim or defense to which the motion is directed. As the Supreme Court explained in Anderson versus Liberty Lobby, only disputes over facts that might affect the outcome of the suit preclude summary judgment. So you need to show facts, genuine issues of material fact. In that opinion, Anderson versus the Liberty Lobby, the court further observes that the materiality determination rests on the substantive law, and it is a substantive law's identification of which facts are critical and which facts are relevant that governs this. So the determination of materiality therefore requires analyzing the logic of the case. The issues must be clearly identified and ordered in relation to each other. So you need to present your issues of material fact in a logical pattern to the court, showing them, Your Honor, we have issues. This person is not Pete. Here's why they're not Pete. This person has not acquired, right, legal rights in accordance with law. There has been no negotiation, transfer, and delivery as required in accordance with law. Here are the facts. Here are the statutes that back up these facts. Here is our argument that backs up the statutes. Because mere allegations are not enough. You can't just attack a summary judge and say, you know what, we've got issues, Judge. We don't believe that. That didn't happen. Back up that allegation. Don't just make it a hearsay claim based on just a statement of facts. Back up your facts. You must factually plead. You must code plead at the same time. This is why we get so much bad case law. It's only half pled. Correctly pleaded out. Factually and code plead. Both. Okay. Determining genuine disputes. What makes an issue of fact genuine? When the papers in support of and opposition to a summary judgment motion in a dispute over a fact, all right, and the fact is material, the court must then determine whether or not the dispute is genuine within the meaning of Rule 56. So the burden is on the moving party, all right? Rule 56A and B establish that the party moving forward for summary judgment must come forward with an initial showing that it is entitled to judgment. All right? So when the moving party bears the burden of persuasion on the issue at trial, its showing must sustain that the burden as well as demonstrate the absence of genuine dispute. All right? So when they file their summary judgment, they're supposed to show in that summary judgment that there is no dispute. All right, that way it satisfies both the initial burden of production of summary judgment motion showing that there is no genuine dispute exists as to any material fact, and the ultimate burden of persuasion on the claim by showing that it would be entitled to a directed verdict at trial. Right? That's the burden that whoever files summary judgment has to show. They have to show there is no dispute, Your Honor. This is why. All right, so before you even get a chance to show, right, that's what they're supposed to show in their summary judgment. Now, the burden on the non-moving party. Once the movement makes a properly supported motion, now the burden shifts to the non-movement to demonstrate the existence of a genuine dispute. All right, so if opposition has filed for summary judgment, you now have the burden of proof to showing that there is a existence of a genuine dispute. Now, under Rule 56E, an adverse party may not rest on mere allegations or denials of the adverse party's pleadings. And that's what we just stated earlier. But the adverse party's response by affidavits or as otherwise provided in this rule must set forth specific facts showing that is genuine issue for trial. All right? Again, you can't just make an allegation. Show it. Nor is it sufficient for the non-movement simply to attack the credibility of the movement's affiance without a supporting factual showing. The non-movement may set forth specific facts by submitting affidavits or relevant excerpts from depositions, answers to interrogatories, or admissions showing a genuine issue for trial. When appropriate, it may simply demonstrate to the court that the record on the motion contains sufficient specific facts to establish the existence of a genuine issue. Okay, so again, you need to follow what the courts stipulate. How do I, all right, as a non-movement, all right, show, all right, that there is a issue of genuine material fact? By submitting affidavits, all right, relevant excerpts from depositions, answers to interrogatories or admissions, showing that there is genuine issue for trial. Okay, let's continue. It may show, for example, that the movement, by ignoring or mischaracterizing relevant facts in the record, raising a genuine dispute, failed to meet its initial burden. So again, it is a non-movement's part to show there is a genuine dispute, that the party filing for summary judgment has failed to meet its initial burden. Rule 56E requires the party opposing summary judgment to set forth specific facts establishing the presence of a genuine issue. When there is no dispute over the sufficiency of evidence establishing the facts that control the application of a rule of law, then summary judgment is appropriate, is the appropriate means of the deciding issue. So in other words, if there was no dispute over the sufficiency of evidence that established facts, all right, that controlled applying of law, then summary judgment would be the appropriate means. Now, such issues include whether an action is barred by statute of limitations, by res judicata, or by collateral estoppel, or by a lack of standing or jurisdiction. All right. Summary judgment should not be denied simply on the strength of the non-moving party's assertion of fact disputes. Such assertions should be put to the test to determine whether they raise a genuine material issue sufficient to defeat summary judgment on the issue of law. So they're saying that in order for you to, in order for the courts to deny summary judgment, is that your assertions, all right, should show that they're raising a genuine material issue that would defeat summary judgment based on the issue of law that you're presenting. The Supreme Court stated in Anderson versus Liberty Lobby, there is no issue for trial unless there is sufficient evidence favoring the non-moving party for a jury to return a verdict for that party. In other words, unless you can show as a non-movement that there is evidence in which you would win going to trial, you are not going to get a trial. They will rule against you.
Hey guys, this is Elizabeth from Chicago, Illinois. I just want to make this video to say thank you to Fraud Stoppers for helping me get a $35,000 keys for cash settlement. Yes, I definitely recommend Fraud Stoppers, especially for anyone looking for help with foreclosure issues. What I can say about them is that they didn't make any false promises. They did exactly what they said they would do. And really, they went above and beyond. So, yeah, that's Fraud Stoppers.
Okay. Rule 56 permits courts to grant partial summary judgments, resolving certain issues or claims while leaving others for trial. And we see that a lot. You'll see many times where they will go through a summary judgment, and they may be 4 or 5 different claims, and they may agree on some of these summary judgment claims. Say out of 5 that they've given you, they'll give the bank 2 and they'll give the homeowner 3. All right, while Rule 56D is most often used to decide entire claims, it is also available for more modest purposes. The rule enables courts to resolve some factual matters while leaving others for trial. In doing so, the court narrows the issues and focuses on the remaining litigation. This is why many times, by the time you make it to court, there's only 1 or 2 issues that pertain to trial. Half a dozen of the other ones have already been taken care of using summary judgment. Okay, let's take a look at Rule 57, Declaratory Judgment. Let's see if this is it. Let's see, before we get there, give me a second. Let's do this. Okay. This is something I'd like to go over. There we go. Okay. Elements necessary for summary judgment. And this is taken out of Lloyd versus Lawrence. And this is 5th Circuit, 1973. And it says, promissory notes are among the most suitable classes of cases for summary judgment because the elements of proof necessary to recover a negotiable instrument are so straightforward. These are the 4 things that they need to do in order to show summary judgment. 1, defendant executed and delivered the note. So you're going to have to show, all right, and again, depending whether you're plaintiff or defendant, okay? Was the note executed and delivered? Yes or no? You know, again, you're going to have to show, was it pursuant to 7501? All right? Actually, this should be plaintiff. Plaintiff executed and delivered the note. Okay, the plaintiff is entitled to enforce. Now, how do we enforce a note? Again, look at Pete. All right, have you acquired rights? So, can we show statutorily, all right, that they're not entitled to enforce a note? Well, yes. So if we can show that they didn't execute and deliver the note, that we can show that they're not entitled to divorce, right? We have 2 issues done already. All right? So we can show issues of material fact, genuine issues of material fact, pursuant to 9312, 3203. We need to make those arguments. We need to back up those statutes with the arguments. 3, defendant has failed to make payments when due under the note. Well, are we talking about the tangible promissory note? Are we talking about the E-note? Okay. Because without knowing who to pay, you would not know how much to pay. So 3, again, failed to make payments. That's going to be a gray area. It just depends on your circumstances. Have you failed to make payments? Yes or no? That's going to take you into a court of equity. You want to stay out of it. The amounts due, well, without knowing proper beneficiary and who to make payments to, that would go to how much is due. Again, the biggest ones are going to be these two. You show issue the genuine material fact pertaining to these two. Again, you must have an understanding. Are they Pete? Have they acquired rights in accordance with law? Just because you are a holder, right, does not make you a holder in due course or a holder with rights legally conferred to you. Just because the company Federal Express has federal in their name, does that mean that they're a federal company? Federal Express. That doesn't make them any more federal than anybody else. That's just the name. So having someone be a holder versus a holder with rights is, again, very, very different. When you're looking at what it is that we're attempting to do, and when you're looking at what they're attempting to do, right, that's what we need to understand. What do I need to do to avoid a Rule 12b6 dismissal? Okay. Here's something I just put this together the other day. All right, to avoid a 12b6 dismissal, let's blow it up so you can read it with me. Okay, to avoid a 12b6 dismissal, a complaint need not contain detailed factual allegations. Rather, it must plead enough facts to state a claim to relief that is plausible on its face. That's important. That is plausible on its face. I see all the time wrongful foreclosure, cause of action. Wrongful foreclosure is not a cause of action, people. All right, second, a pleading must contain a short and plain statement of the claim, showing that the pleader is entitled to relief. While Rule 8 does not demand detailed factual allegations, all right, it demands more than an unordained, all right, the defendant unlawfully harmed me accusation. And that's out of Ashcroft versus Iqbal. Threadbare recitals of the elements of a cause of action supported by mere conclusionary statements do not suffice. Moreover, the complaint must give the defendant fair notice of what the claim is and the ground upon which it rests. Under Rule 8D, each allegation must be simple, concise, direct, and complaints that are verbose, confusing, and consulsory violate Rule 8. So I've seen a ton of pleadings, and the majority of the pleadings that I see out there, they're just stating facts. They're not properly code pled. I see where in many cases they're citing statute of frauds. Fraud is involved. Oh my God. Well, if fraud is involved, right, did they cite all causes of fraud? Because you need to cite each cause of fraud, all all right, each action, and then back it up statutorily. And that's not done. You know, time and time again, you know, I see where they say, okay, well, I've got fraud stated over here. I've got fraud in the factum, okay? But it's not backed up statutorily. You need to cite all the causes of action for fraud. And again, and you must prove it more than just a mere allegation, you know? So if you're citing all of the causes of action for fraud, and you're backing up each one, all right, with the statute, each one with an argument, all right, then you've correctly code pled and factually pled what you were supposed to do. All right, so what we are doing in our analysis, and I need to have you understand what is our analysis. All right, so we're going to go through that in a little bit, but what I'd like to do is take a minute and just show you real quickly. We're going to go through, I put this together as far as showing what our investigation is. How is what mortgage compliance investigator different than everyone else, right? Because we claim we lay the foundation for which everything else is built off of. All right, so how do we do that? All right, so I'd like to take a few minutes and just go through this briefly and show you, all right, what exactly an investigation is with mortgage compliance investigators and how does this pertain to the actions that you're going to be taking forth. Because in my opinion, before you do anything, we need to do a chain of title analysis and investigation, all right, before any action is taken. Because without a solid foundation as to going forth to determining what has been done or what has not been done, you can't say anything. We're just going to take a few minutes and just go through this. And I just put this together, so bear with me. You may have seen this on your, if you looked at my YouTube or whatever, so I'm not going to spend as much time as we on it. So basically, what is our investigation? What is it comprised of? All right. So before I walk you through our investigation, you need to have an understanding is what is it that we're doing? Basically, it's like peeling an onion. There's multiple layers. All right. One. All right. At mortgage compliance investigators, we are licensed private investigators, licensed through Texas DPS. There's our website, all right, where you can go to the state of Texas, all right, website, and you can look up, all right, yes, we are licensed. Yes, we carry $1 million insurance, all right. So we are licensed to do what we're doing, all right, and peeling this back as an onion, all right, we go through many different layers. So we're going through the elements of mortgage, all right, and how are these elements governed? So we're looking at chattel paper documents and tangible documents. Everyone says, Joe, what do you guys look at? We look at everything. Look at tangible promissory note. All right, again, we already went through it. What is a tangible promissory note? We go through the tangible security instrument. What is a security instrument? A writing in tangible form to memorialize the obligor or debtor's pledging of an asset or property as an alternate method to secure payment to a tangible obligation, if in accordance with all applicable laws of local jurisdiction, it's governed by local laws jurisdiction in which a real property resides. And I believe this in about 95% of these security instruments, if you're looking at a Freddie Fannie multi-state use instrument, it's going to be probably Covenant 16 or Covenant 15, all right, where it talks about what laws govern the instrument. And if you're with the Ginnie Mae, it's going to be on Covenant 14, all right, governing laws, rules of severability. So it tells what is it. We look at the security interest, the pledging of the tangible alternate real property rights for payment. Again, we get more into a more definition. You can come on YouTube and spend an hour and go through this. But so our investigation goes into the promissory note. We also look at the intangible E-note. We also look at the intangible payment obligation. All right. This looks exactly, again, breaking up what it is we're looking at. The intangible payment obligation. An electronic transferable record created during securitization and signed in accordance with the e-sign act that commits the maker, the account debtor, or the intangible obligor to pay its specified sum on demand. Again, it's not governed by UCC Article 3, all right, and it's to an intangible obligee. Transferable records are governed by UCC, and the security interest securing transferable records are governed under UCC Article 9 because it pertains to personal property, not real property. We look at security interest. Again, we break it down into exactly what it is we're looking at. Layer 2, I look at land records, all right, which are documents of transactions being claimed that have been recorded into public record, thus giving constructive notice to the world. Again, it's like peeling an onion. Go to layer 3. We look at statutes and law. United States Code, federal law, Uniform Commercial Code, state laws, local laws of jurisdiction. Again, more and more. All right? What should have happened? All right? So if you're from an RMBS, all right, we look at the first sale from Party A to Party B, along with the first assignment, with Party A releasing its security interest in the security instrument, and assigning that interest to Party B, and recording this transaction in public record. This is all in our investigation. I then look at it, second sale, if there is to be one, from Party B to Party C, along with then assignment with Party B releasing its security interest in the security instrument, and then assigning that interest to Party C, and then recording this transaction in the public record. These are all transactions that we're looking at for each one that I do. The third sale from Party C to Party D, along with an assignment from Party C releasing security interest and the security instrument and assigning the interest to Party D, and then recording this transaction in public record. Because remember, there is a timeliness to all of these transactions. Again, if there's a fourth sale, we do the same thing. All right, then we do a comparison. Now I take all the documents and records of tangible and intangible, and I compare them to statutory requirements of law pertaining to the entire mortgage loan instrument that consists of tangible promissory note, tangible security instrument securing the indebtedness, and the intangible obligation, which is promised to pay. This is very important. This is why when I look at the documents, because many times I have certain parties that they'll give me 100 documents. And I know I said I need all of them, but some of them go back, 5 or 6 years to an assignment of a deed of trust that was done in 2004, and your loan that we're looking at is in 2009. So again, we need to do a comparison of all documents that I see in public record. This is what it looks like on my desk sometimes. All right, so we go through that. We then go into other databases. I go on the Security Exchange Commission. We go into the pool servicing agreements, 424, BFI prospectus, free writing prospectus, trust agreements, circular settlements, selling guides, custodian manuals. So depending on your particular instance would depend where we would go for this information. So whether you're a private investor, whether your loan is with whomever, depending on your circumstances, it would be depending on what we're looking at. We look at what did happen. Oh my goodness. All right, so I've taken all these notes, all these transactions, and what actually happened? Well, what did happen doesn't match what was supposed to happen. Right? So what did not happen or not take place in accordance with statutory requirements of law, as well as the governing documents that were required in order for the true sales to take place. What requirements were violated in regards to keeping tax status as a REMIC? Were the timing requirements met? Again, all these questions, this is what goes into the investigation. So it's not something that is just thrown together. There's a lot of information to the methodology in which we achieve the end result. In conclusion, we now have to put all these findings into a concise package which consists of chain of title analysis, the infographic, right? And these infographics are specifically for MCI, right? We've created them. No one else has. It took us about 4 months to come up with them. And the reason they were created was because Damien asked me one day, Joe, we need something to show. We're making all of these arguments and we have nothing to back up what we're saying. As far as visually, some people are visual learners, some people are audio learners. So for visual, we sat down, and because there are charts out there that my mentor has created, that other people have created, but they're so complex, these simple lay people do not always have the time to sit down and spend 5 or 6 hours on one chart. So we probably got about 30 different charts. So depending on your situation, the majority of the time we're able to come up with a chart. However, if you are with a private investor, I do not have a chart probably readily available. And if I were to take time and do one specifically for you, it probably costs upwards of around $3,000 or $4,000 the time that's invested to get the PPMs, private placement memorandums, and other documents that we do not always have access to. So depending on the access we have to the documents, to the entities, would have a determination as to what type of chart we would come up with. Information on endorsements we have. Any documents that I procure regarding trust agreements, pool servicing agreements, prospectus supplements are all part of the package that you would receive as well as a voluntary liens report as to what is filed in public record, an affidavit of fact. The affidavit of fact is strictly that, an affidavit of fact. It states facts that I have found. Now, I'm going to go over how to use the analysis in a few minutes. And what I'd like you to understand is that, all right, it is that analysis which is laying the foundation for the information for the declaratory judgment. All right? Because for so long I have stated everyone needs to take the information within the analysis and put it in the four corners of your pleadings. And then I look at the pleadings and it is not what is in the analysis. And no, I'm not an attorney, but I know that every time somebody likes to reinvent the wheel, and that's okay. Well, why reinvent the wheel if you don't have to? So, anyways, the color of title. This is what the analysis shows, all right? Is there a color of title? Yes, there's an appearance of a legally enforceable right of possession or ownership. Right? The problem is color of title is not title with rights acquired. So this is where the investigation will show they only have a claim to a color of title. And when you understand that it was not done in accordance with law, and you understand that you're challenging, all right, using slander of title as a cause of action, they slandered title of my property. I don't have marketable title. Someone has a claim, all right, and I want to disprove their claim. And I want to do it lawfully and legally in accordance with law, not in a court of equity. So what I'd like to do, let's see, next we got, oh, that's it. All right, so it's 3 o'clock. Okay, we've gone 4 hours. Let's take a quick 15-minute break. When I come back, I'd like to go through an educational package and explain just real quick what we're doing and how it's being used and what exactly the educational analysis is and how to use it. Because it does not have 4 legs of its own, and you need to use it and understand it correctly. So I'd like to show everyone, what it is and what I'm stating on it. All right? Because we did change the format of our educational analysis, as before it was coming out in the form of an affidavit. However, yes, I can say today, yes, I was giving conclusionary statements. Yes, I was leading the court. All right? Yes, I was stating opinions. Yes, some of that was hearsay. No, I did not always have firsthand knowledge of these cases. All right, so as an affidavit, there were ripping apart what I was building. All right, because an affidavit is specifically designed to state facts. However, as an educational analysis, I can say everything that I said in that affidavit as an educational analysis. All right? So I am not stating that it is an affidavit. It is an educational analysis. This is my analysis of my interpretation, all right, being a licensed private investigator as to what was to take place, what did take place, what did not take place in accordance with law. All right? So now I can state, here's what law says. Boom, you didn't follow it. All right, here's what statutes say. You didn't follow it. Here's what the PSA says. You didn't follow it. Here's what records in public, county recording office say. Now as an analysis, it is an analysis. Now my affidavit says, I have looked at a note pertaining to John Doe. Here is what I saw. 1, this copy of a tangible promissory note shows an endorsement from Party A to Party B. 2, copy of this note in the form of law shows an incomplete stamping to an as of yet unnamed payee. Boom. I have looked at a deed of trust. Here's what I saw. And again, I state facts. Those facts back up the analysis. So when used correctly, all right, you can put that affidavit of fact into court record. You can put the analysis as an exhibit, as an educational analysis in the record. They're not going to like it. You're not there to make friends. You're there, all right, because there is a controversy. So whether you're on opposing or whether or not you're on taking action on offense or defense doesn't matter. We want to go to a court of law, all right? We want to bring the correct arguments. We want to lay a proper foundation. I looked at this. I looked at this. Here is the results. Here's what state laws say. And when you understand that, that makes it a lot easier. Okay, everyone. I hope everyone is back. I hope everyone got a rest because we're about ready to get started again. So we were talking about using the analysis. All right, because the analysis is an analysis. So I'm going to pull up one right now. Let's go through it a little bit. Okay. See what this is. All right, 1 second. Okay, is everybody on? Thomas, can you hear me? Type in the box if you can hear me.
I can hear you.
Okay, thank you.
You're welcome.
Okay, everyone, here we go. Hope you're enjoying all this fun that we're having today. All right. So we're going to go over an investigation. We're not going to spend a lot of time on it because I could spend a couple of hours. Just ask the attorneys that I handed to and the opposing counsel when they depose me. I tell them to go get a cup of coffee or a glass of wine. Actually, after reading it, they probably go get a bottle of wine. All right, so this is a copy of just a sample of an investigation and analysis. Now, what makes this a little different is that you are going to use this as an educational piece to educate you on what was to happen, what did happen, and what did not happen to issues pertaining to title to your property in accordance with law. And if you come to the same conclusion that I do, then I've done my job. Now, the only difference is I've already looked up the statutes that apply to the property. I've gone through public record. So this is meant to educate you. Again, you can put it as an exhibit into your complaint, all right, as an educational analysis, all right, which is backed up by an affidavit of fact, which references items we talk about in the education packet. So when we're going through this, you'll notice the first 8 pages, we go into very detailed interpretation regarding conveyance of a securitized mortgage loan. And again, if there are any attorneys on board, I would encourage you to take the time and read it, because this is about 4 years of work that has been put into this. You know, MCI has created this from scratch. We're setting the bar that everyone is now trying to pull themselves up to. So when we go through, we talk about the elements of a mortgage loan. It's written how it is governed. Again, we've gone through a lot of this information in the beginning. However, again, we've put a lot of work into it. This has been vetted out by numerous individuals of much higher learning than I am. So once we put this on paper, we said, all right, we need other parties to look at this. Are we stating what is true and factual? Is it correct? Yes. All right. You are not going to find any other information like we are giving you any other place from any other source, unless you are academia. All right. Even the attorneys that tell me, Joe, I've been to Harvard Law School. Big deal. Have you applied what you've been taught correctly? No. Right? Just because some attorney has taken a UCC class does not make him an authoritative figure in understanding Uniform Commercial Code or their state's equivalent thereof. It is your job to have an understanding as to what was to happen, what did happen, and what did not happen in accordance with law to your property. Until that fat lady sings, don't you give an inch. And even if she sings, you just choke the life back into her. All right, so we need to go through, we need to understand what did happen outside of law. Again, this is a very in-depth reading, the first 10 pages. So I ask you, don't try to skim read this. All right, this was written on purpose, all right, and it was written in legalese, and it was written for the common man as well. But there is no sense for me to give you all of the information, all right, without putting it in the most precise context that we can give it to you. So again, when you go through it, you're going to read everything, all right? And if you don't understand it, walk away for a few minutes, come back and read it again. Make a copy of it, highlight it. Again, I have many parties that, Joe, that is not grammatically correct. You know what? This is an educational analysis. I am not an English teacher, an English major. If I've missed an apostrophe or whatever, it is just a minor Scrivener error, and you will just deal with it because it's an analysis. It does not take away or make this any less an analysis based on a Scrivener error. Now, while I have taken the most utmost, all right, precautions and doing everything I can to make sure that this is grammatically correct, again, I am not a learned English major or an editor and do not claim to be. So what you are getting is an analysis, and as such, use it as an analysis. All right, so we've gone through the first 8 pages, and again, it's the most comprehensive understanding you're going to get. When we get to page 10, again, for this particular one, we go into parties, all right, that are pertaining to the transactions. All right, the borrower, the co-borrower, the lender, the trustee, the dollar amount. Again, anything that is relevant to parties in the transactions. Oops, sorry, going the wrong way, everybody. Okay. Section 2, okay. In this particular one, you're also getting the information that is in the databases in which I search. All right, I've got numerous sources, and it just pertains to, again, the information that we find for the asset of the mortgage loan instrument that is sold to a party claiming an interest of your mortgage loan instrument. It says here, loan is found. These are classes that are within that trust. Depending on your particular situation, I may have a lot of information here, and you may have a little bit of information there. Okay, we get into the infographics, where we're talking about an introduction as to what is the infographic, all right? The infographics were created, again, to give a one-page visual representation, okay, of the transactions pertaining to your property. Again, we've got about 35 different charts that we use, whether you're with a Fannie Mae, Freddie Mac, Ginnie Mae, if you're with an RMBS, if you're in a hybrid, if you have a sponsor, if you don't have a sponsor, if you have a depositor, if you don't have a depositor. And again, depending whether you have MERS or whether you don't. So again, these pertain to MCI, mortgage compliance investigators. Took me about 4 minutes to come up with the type of graphics we were going to use, and then I had another party within MCI by Bradley Walker that actually put these down, and we created these charts. In this chart, all right, if you look at it, it says RMBS loan securitization diagram. On the left-hand side is what is required by statutes and trust documents. On the right side is what actually happened. So on the left side, we see borrower, we see Jane Doe. It said, signed at closing. And there's a date right there. There's a closing date. All right. Now it says, okay, let's look at the note. Well, we have Doe's note. We have Doe's mortgage. All right. And if we look really, really close, we can see the payment obligation. This is the intangible obligation right there. All right? That is the intangible obligation. That is inside the tangible promissory note. Here's the Doe mortgage. All right, so at closing on July 6, 05, the mortgage went to County Recorder's Office. It was signed, recorded, indexed. We then have a properly perfected lien and was sent back to the originator. All right? Now, the originator, all right, is supposed to transfer through endorsement and negotiation the Doe note and the intangible payment obligation. The mortgage then goes back to the County Recorder's Office where an assignment is recorded, filed, and indexed, sent back. Now goes to the sponsor seller, the party that was sold the note, Doe tangible promissory note, and the Doe intangible payment obligation through negotiation, transfer, and delivery. All right? The mortgage was recorded and an assignment was done. Again, so we do this for all the parties to the transaction. You notice every time there is a properly perfected lien, assignment is recorded, note is done. This is what is to happen. It goes all the way down to the trustee. Trustee of the trust takes it, boom, oops, and they end up selling to the trust, the RMBS trust, all right, on August 17th of 05, all right, the note, tangible promissory note, the payment intangible obligation, and the mortgage, all right, which has an assignment which was recorded in public record, all right, at the County Recorder's Office, all right, and all of this happened, all right, from July 6th of 05 down to August 17th of 05, and it was all done, okay, in a month and a week. They did all these transactions. That's what required by trust and statutory requirements of law. That's what the pool and servicing agreement. What actually happened? All right, Jane Doe signed at closing July 6, 05. We have Jane Doe's note. We have Jane Doe's payment obligation. All right, Jane Doe's mortgage was signed, sent to County Recorder's Office, was index filed, recorded, give constructive notice to the world. We have a properly perfected lien, sent back to the originator. The originator then scans it into their system, right? It's stamped with a payee to an as of yet unnamed payee, and then the note is often vaulted or destroyed. All right, so what they do after that is that after they've scanned it in, they rip out this intangible obligation. They rip it out and they sell that payment obligation, all right, to the sponsor seller. They sell that payment obligation to the depositor. The depositor sells that obligation to the trustee of the trust. Right. There are no transactions recorded into public record, all right, for this particular instance to back up any of the transactions that are taking place electronically. Why? Because we don't have any laws that relate to negotiation of electronic records, negotiable instruments. There is no electronic negotiable instrument law, only negotiable being tangible. So when you look at what was to happen, that looks nothing like what was to happen. Now, When that intangible obligation is stripped and transferred electronically, all right, your tangible paper note is no longer eligible for negotiation pursuant to, in this case, I use California Commercial Code 3203D. Why? Well, if we go to 3203D, let's take a second and do that. My computer's a little slow, so 1 second. Okay, here's Commercial Code 3203. All right, transfer of instrument, rights acquired by transfer. D states, separate so we can read it. If a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this division and has only the rights of a partial assignee. Well, what they're saying, all right, the minute they've stripped out this intangible obligation, the mortgage loan instrument being the DOE note, tangible, the DOE mortgage, and the DOE intangible obligation is now less than being a complete instrument. We have 3 parts, 1, 2, 3. The note, the mortgage, and the payment obligation. When you sell one part of it, all right, you sold 1/3. 1/3 does not equal 3/3. So the paper tangible note is no longer eligible for negotiation. So what you're doing is they are selling the intangible obligation, all right, electronically with the click of a button. Now, your security instrument, right, no longer is there any more assignments of record memorializing the negotiation of the tangible promissory note. It stopped. But yet years later upon default, all right, we see that there's purported 2 documents purporting to be assignments of record. The problem is these assignments are not timely and they're less than the entire instrument. They're purporting to do an assignment, all right, and this date was March 2nd of 06. Well, March 2nd of 06 is after the closing date of August 17th of 05, all right, and that assignment should have had an endorsement from the note to back up the assignment. We don't see any. So it's pretty interesting to see what they're purporting to do and what they're actually doing. So it's, when we look at it, what I am looking at is, did they follow law? Yes or no? I don't want any gray area. Well, you know, this is what they've been doing for years. I don't care what they've been doing. This is what our policy dictates. I don't care what your policy dictates. You're holding my feet to the fire. We're going to hold your feet to the fire. Okay, so again, depending on your situation will depend on what type of chart we have. So this one pertains to an RMBS. We have special charts for GSEs, special charts. This one does not have MERS. I have charts with MERS, without MERS. So again, depending on your specific transactions, there's a big difference. So again, we get into Section 3 where I go into what documents have I looked at. These are a list of the documents I've looked at. I then get into a discussion of what I've looked at. So depending on what I find will depend on what I'm going to state within it. As we go through it, we talk about, let's go Okay. The PSA. Here. The written agreement that created this is a PSA dated. So I'm stating here, okay, here it is. Where did I get my information? Well, here it is. The PSA dated August 1st, 1705. It's a matter of public record. Available on the website Security Exchange Commission. It's also described in a prospectus supplement, also available. So again, I'm stating where I get my information. Governing law, all right, it's from the PSA, as stated on page 39 of the Pool and Servicing Agreement, dated. All right, New York Trust Law. Well, I got that from Chapter 17B, subsection 7-2.4. This is New York Trust Law. This is what it says. So I'm not making anything up. All right, this information here is from I pull a voluntary liens report for every property I look at. About 95% of the properties I'm able to get a report, which I go into public record and I see, what am I looking at? What's been filed? What hasn't been filed? This is information taken directly out of there. So it says, okay, in public record, record number 18, there was an assignment. Here's the recording date. Who's the borrower? All right, who's the lender? Who's the previous lender? So when we go through it again, if you have more than one assignment, then we have more than one. We talk about prohibited transactions. Where am I getting the information? I'm talking about IRS. Okay, here's statute for IRS, Title 26, Rule 860. CFR 1860D, identification of assets. The formation of the RMIC does not occur until 1. The sponsor identifies the assets of the RMIC, such as for execution and indenture with respect to the asset. So it says that these RMICs don't even occur unless they've identified the assets. So if they're saying that they've acquired these assets prior, all right, to the assignment of mortgage or assignment of deed of trust, either they're lying to the trust or they're lying to the parties in court. So who are you lying to? One or the other. If you're attempting to do an assignment, remember the assignment is to memorialize a transaction. It doesn't cause the transaction. So if you're saying that we're memorializing a transaction dated, August 23rd, 2013, all right, and yet the trust closed in 05, all right, so we're talking 8 years difference. Either you lied to the trust and that asset was never with the trust, okay, or you lying today trying to put it into the trust and it's not timely, all right, because that closing date is long gone. So either the transaction happened today, all right, on the date of the assignment, and then that is to be shown through endorsement, transfer, and delivery and negotiation. So we would look to the note and see how they named to the note. And then we look to all subsequent endorsements that were to take place as well. That's why I said this investigation analysis lays the foundation for any action. And this one, it was California, so we had substitution trustee. Well, why is that important? Well, because the substitution trustee comes from the assignment of deed of trust. And this one, they had multiple substitutions. You had 3 of them. And we talk about the NOD. All right? Why is the NOD irrelevant? Now we got a 4th assignment, substitution of trustee. Again, I don't make up any of these documents. All right? All I'm going through and reading and understanding them. When I'm talking about rights, California Commercial Code, I didn't put that there. All right? This statute has been codified by the state of California legislature. I'm just reading it, and this is my understanding. If that's not what it says, if that's not what it means, okay, then change the law. So it is this information that lays the foundation for the declaratory judgment as to the determination of rights acquired by parties in this controversy. Right. So this slander of title, all right, that I'm stating in which there's a controversy, all right, that's happened because I have an investigation that's shown me all of this. All right. And declaratory judgment right now is, in my opinion, one of the best tools out there. One of the things recently that came out, and let's pull up a few cases that I just happen to have. Summary judgment. Let's see. Bear with me for a second. Okay, where are we at, Joe? 1 minute. Okay. Let's go. Here we go. Let's see, is it Yarbus? Give me 1 second. Page 3. I think this is it. 2, 3. There we go. Again, while the homeowners lost this case, the reason I'm showing you this case is not, it doesn't matter that it does matter that they lost, okay, and I feel for them. However, when you look at what the courts are saying, all right, the courts stated, the Yarbas are correct when they point out that an obligor on a loan may defend against an assignee's efforts to enforce an obligation on any ground which renders the assignment void. Not voidable, void. Okay. And the Yarbas are correct when they note under Texas law, a deed that is forged is void. Their fault, however, lies in the strength of the pleading of this claim. The Yarbas offer no factual support for their legal conclusion. So now, even though they lost, it's telling me, wait a minute, we are correct in what we are doing and articulating our arguments against an assignee's effort to enforce an obligation. Because we are going to show that it is void, not voidable. Here's a no case that just came out a few days ago, July 24th. So I'm going to try to stay up on top of as much of this as we can. We have many parties that help do this. So it's only 52 pages, but let's see, where did I go through? Basically, in a nutshell, here we go. An assignment of deed of trust. An assignment of deed trust to Deutsche Bank is a cloud on the appellant's property title, not a trespass to try title claim. So again, I'm just using law. I'm using what was written. Where am I looking at? Oh, but I don't think I have a chance to highlight it. Okay, here we go. Okay, Quine title. The corporate assignment from Argent to Deutsche signed on February 13 by Bly was ineffective and void for multiple reasons, preserving the right to amend and add additional defects. Okay. Corporate assignment took place 6 years after the pool and servicing agreement cutoff date. Okay. Then they've actually attached Brian Bly's deposition and how they show how the assignment was void. But based on that void assignment, they reversed summary judgment against the Vasquez. So Deutsche Bank now is getting this remanded back to district court. All right, and they have to follow what the appellate court said. So declaratory judgment, in my opinion, is what has been missing. Without making any erroneous claims, all right, we want to go into a court of law and ask the court to make a determination. When we look at, let's see, what is it? I think it's, let's see. We've got lots of cases. Baines versus Quintano. There's a good case for Merrill. Let's see, is this it? Wells Bank versus Robo. Okay, I think this is it. This is the case that came out of New Mexico, and right now this is okay. The opinion was they've overturned. The Bank of New York did not establish standing, all right, did not establish lawful standing to file a home mortgage foreclosure action. So what's happened is that the bank has come forth with a claim that they've acquired rights, all right. Now, they've also gone through the Home Loan Protection Act, which we're not going to get into, but it was pretty interesting that the Supreme Court reversed the Court of Appeals and the District Court and sent this back to District Court with the instructions to vacate its foreclosure judgment and dismiss the Bank of New York's foreclosure action for lack of standing. Where, let's see, it's not that big, but we've gone through it. Here we go. They talk about standing is to be determined as of the commencement of suit. A plaintiff has no foundation or law or fact to foreclose upon a mortgage in which the plaintiff has no legal or equitable interest. All right? Now, we're talking about declaratory judgment, resolving these equitable claims to title. So in here it's saying, according to American jurisprudence, right, second mortgages, a plaintiff has no foundation in law or fact to foreclose in which the plaintiff has no legal or equitable interest. One reason for such requirement is simple. One who is not a party to a contract cannot maintain a suit upon it. If the entity was a successor in interest to the party on the contract, it was incumbent upon it to prove it to the court. In this instance, the Bank of New York had the burden of establishing timely ownership of the note and mortgage to support its entitlement to pursue a foreclosure action. One who holds a note secured by a mortgage has two separate and independent remedies, which he may pursue successively or concurrently. One is on the note against the person and the property of the debtor, and the other is by foreclosure to enforce a mortgage lien upon his real estate. So, remember, it is their choice whether they want to collect upon the note or whether they want to use an alternative means of collection beyond the security instrument. They're greedy, they go for the foreclosure. Okay, none of the bank's evidence in this case demonstrated that it had standing to foreclose. The court said, while we agree with the bank that our state's UCC governs how a party becomes legally entitled to enforce a negotiable instrument, such as the note for a home loan, we disagree that the bank put forth such evidence. Again, remember, you're setting up, all right, for the appellate court. We reject the bank's arguments that it can enforce Romero's note because it was assigned the mortgage by MERS. An assignment of a mortgage vests only those rights to the mortgage that were vested in the assigning entity and nothing more, which we talked about earlier. If you've acquired no rights, you can't assign any rights. Here, as Equity One and MERS explained to the district court in joint filing, seeking to be dismissed as third parties to Romero's counterclaims, MERS is merely the nominee for Equity 1 in the underlying mortgage and was not the actual lender. Because MERS is a national electronic registry which keeps track of the changes in the servicing and ownership of the mortgage loans. So again, this is not something that we're making up. The courts are slowly starting to get turned around. Some states are harder than others, such as New Jersey or Florida. So again, it's just thing we need to, take a look at. Okay. As a nominee for Equity 1 on the mortgage contract, MERS could assign the mortgage, but lacked any authority to assign the Romero's note. Although this court has never explicitly ruled on the issue of whether the assignment of mortgage could carry with it the transfer of the note, we have long recognized the separate functions that the note and the mortgage contracts perform in foreclosure actions. Holding that because the assignment of mortgage to a bank did not convey an interest in the loan contract, the bank was not entitled to foreclose on the mortgage. That the right of the assignee to enforce the mortgage is dependent upon his right to enforce the note. And noting that both the note and the mortgage were assigned to plaintiff, having the right under the statute to enforce the note, he could foreclose the mortgage. A mortgage securing the repayment of a promissory note follows the note, and thus only the rightful owner of the note has the right to enforce the mortgage. So, the mortgage only secures payment of the debt and has no life independent of the debt and cannot be separately transferred. If the intent of the lender is to transfer only the security interest, in the mortgage, this cannot be legally done. And the transfer of the mortgage without the debt would be a nullity. Again, you need to really look at that. If the intent of the lender is to transfer only the security interest, being the mortgage, this cannot legally be done, and the transfer of the mortgage without the debt would be a nullity. The separate contractual functions where the note is the loan and the mortgage is a pledged security for that loan cannot be ignored simply by the advent of modern technology and the MERS mortgage electronic registry system. Except for the inadmissible affidavit of Ann Kelly and the trial testimony of Kevin Flanagan, nothing in the record substantiates the bank's claim that the MERS assignment was meant to memorialize an earlier transfer to the Bank of New York. Accordingly, neither the MERS assignment nor Flanagan's testimony established the Bank of New York as a non-holder in possession with rights of a holder by transfer. So again, we're talking about rights. How did they acquire rights? What is in the record? Okay. Then we're going in, they get into the home loan program that they have for state of New Mexico. But in a nutshell, again, this is a very good case because it's talking about assignments. It's talking about the mortgages as how one can only assign rights that it has been given. You cannot assign the note. You've never acquired rights to the note. That can only be done through endorsement, negotiation, transfer, and delivery. And this court got it. And then there was another case that came out directly after that, and that was in the Quintana case. And in this one, again, this was another one out of New Mexico that came out. Again, this came out this year, February 27th. I'm not going to go through the whole thing, but we've already gone through again. Let's see. Okay, this case requires us to address several problematical and reoccurring issues in New Mexico home mortgage foreclosure proceedings, including the kind of evidence required to establish standing to foreclose, to the extent to which a holder in due course may be subject to a borrower's enforcement defense based on claims that the original lender violated New Mexico's Home Loan Protection Act. So again, this is a very good case as well. They're talking about standards of review. This court reviews de novo an order granting or denying summary judgment. Summary judgment is appropriate when there are no genuine issues of material fact. We talked about this earlier today. Again, when is summary judgment appropriate? When it is not. What says here, line 14. Summary judgment is appropriate when where there are no genuine issues of material fact, and the movement is entitled to judgment as a matter of law. On review, we examine the whole record for any evidence that places a genuine issue of material fact in dispute, and review the facts in a light more favorable to the party opposing the motion, and draw all reasonable inferences in support of a trial on the merits. The burden rests on the party moving for summary judgment to establish that no genuine issue of material fact exists for trial, and that the movement is entitled to judgment as a matter of law. If the movement fails to meet this burden, summary judgment is erroneous. All right, line 8. B, summary judgment was improper on the issue of standing. Okay. So again, they've gone through the whole process again, 10, 11, 12, 13, where they're talking about, did they establish standing? No. Okay. You go here, line 16. The bank also argues that the assignment of mortgage by MERS served to transfer the note to the bank, an argument rejected in the Bank of New York and similarly reject here. As we explained in the Bank of New York, MERS acted only as a nominee for lending to track and record the mortgage lien through its electronic database. Therefore, MERS lacked any authority to assign the homeowner's note. The MERS assignment cannot substitute as a transfer of note. All right, the fact that the board of First Franklin Financial passed a signing resolution effective November 1st, 2008, authorizing Crystal to prepare and execute documents on its behalf is immaterial. Even if we ignored decades of contract and property law principles and accepted the bank's argument that the MERS assignment was meant to transfer the note, the backdated assignment conflicts with the past due notices and modification letters. There still exists a disputed material fact that anyone other than First Franklin held the Quintana's loan through late 2009 is reflected in the loan servicing records alone. So we have a lot of information coming out, people, a lot. And again, this is one, if you like, I can send you a copy. I've already gone through it. Again, summary judgment, they ruled was in favor or was improper. They talk about being a holder in due course. So again, this is a very good ruling. They reversed the holding of the Court of Appeals in granting a summary judgment.